Good morning. Bonjour. Guten Morgen. And welcome to a conference of global perspectives, regimes of redress, reparations, transitional justice, and the rule of law, hosted by Tulane Law School in New Orleans, Louisiana. My name is Robert Wesley. I am a member of the Tulane Law faculty, and I am the Gordon Gamm Faculty Scholar for 2017 and 18. Mr. and Mrs. Gamm will be present this weekend at the conference, and I would like to begin my remarks by expressing my deepest and most sincere gratitude to them for sponsoring the conference and making it possible for all of us to come together this weekend. I would also like to thank Carol Lavin-Bernick Faculty Scholarship Fund for its co-sponsorship of the conference. I would be remiss if I did not also thank my colleagues who helped to organize the conference, Tulane Associate Professor of Law, Suru Montambanazzo, who's also acting as our stage manager today, Tulane Associate Professor of History and Director of Africana Studies, Laura Roseanne Adderley. I'm told that Roseanne will be here later today as well. And Tulane Associate Professor of History, Marlene Atta. In addition, I would like to thank Dean David Meyer for supporting and believing in the value of hosting an international and comparative exchange on the topic of reparations. Although the Dean could not be here this morning, he plans to join the conference later today. A special debt of gratitude is owed to two additional people. First, my research assistant, Jake Buttery, who's currently in class, but he'll be here after class. Jake has done a tremendous job in helping to make this conference happen, and it really would not have been possible without his focus, his diligence, attention to detail, and willingness to send and receive countless emails. Secondly, I also want to extend a heartfelt thanks to my administrative assistant, Andrea Bragalia. Despite extremely tragic circumstances in her family, Andrea returned to work just last week, I believe, in time to ensure that all the arrangements for food, housing, ground transportation, and technical assistance for our conference presenters was taken care of on time. Today, we are fortunate to have speakers from across the country and around the globe: the West Indies, Japan, India, Australia, England, France, the Netherlands, Germany, and of course the United States. Collectively, our goal is to examine the contours and limitations and strengths of different regimes of redress in response to human rights violations in order to begin to draw some normative conclusions about the relationship between transitional justice and the rule of law. I'm very excited to begin that discussion with such a distinguished group of experts. For me, this conference is the culmination of years-long efforts to spark a serious and thoroughgoing dialogue about the failure to repair the injuries of African enslavement by Western colonial powers. I hope this conference will, in addition, be the beginning of an extended conversation about the indispensability of establishing a norm of redress in response to human rights violations. In recent years, reparations discourse has taken a historical turn by re-examining what we thought we already knew about historical injustice and atrocity. This turn to history has allowed scholars and eventually the public to gain new insights on topics that seem to some to have been drained of any further usefulness. The Germans have a word that roughly translates as working through the past, Vergangenheitsbewältigung. I agree with Thomas McCarthy. We need some Vergangenheitsbewältigung in the USA, but not only in the USA. It is my hope that looking at the question of redress in a comparative context will spark fresh ideas, political commitments, and solidarity across the boundaries of difference, and give impetus to the struggle for human dignity. The program will start with a panel on reparatory justice for colonialism and imperialism. The speakers include Professor Tayyip Mahmood of Seattle University School of Law, who is also the director of the Center for Global Justice, Caleb Lauer, who is a PhD student at Vasily School of International Affairs. He's also a freelance journalist. We have, in addition, 2 graduate students from Columbia University. We have Anna Christine Shearer. She's a 3rd-year PhD fellow in the Department of Anthropology and the Institute for the Study of Human Rights at Columbia. And Howard Recavia, am I getting that correct?
Yeah.
Recavia Taylor, who is a 3rd-year PhD student in cultural anthropology, also at Columbia. The speakers will have 20 minutes each, and then we will conclude with a Q&A session. We don't have a moderator, so the speakers will decide among themselves what order they will present. Before I turn over the floor to the panel, I'd like to say a few words about why I think reparations is so important. Reparations is a story of summary removal of a population from homeland to concentration camps. The story of interrupted lives in the case of Japanese Americans is followed by a story of redress and redemption. 4 decades after the end of the Japanese internment, American justice was redeemed with apologies from the President and Congress, a grant of $20,000 for each survivor of the internment, and in the courtroom, reversal of the criminal convictions of Yasui, Hirabayashi, and Korematsu. Reparations is a recognition of and empathy towards how trauma accompanies abuse and frequently outlasts it. Recently, archaeologists believed that they had located the slave ship Clotilda along the shoreline of the Mobile River. The captives brought aboard the Clotilda are the only group of enslaved Africans brought to the United States who know precisely where they were taken from, precisely when it happened, the name of the ship that brought them, and where they ended up once in the United States. Many of those aboard the Clotilda ultimately settled in a community they created near Mobile, Alabama, known as Africatown. The captors were freed just 5 years after they were enslaved, thanks to the end of the Civil War. The group, 110 strong, originally asked their captor, an Alabama steamboat captain and plantation owner named Timothy Meeher, to pay for passage back to Africa. So they made their requests for reparations. After he refused, they appealed to the U.S. government to no avail. Ultimately, some of the members of the group bought a small piece of land north of Mobile, Alabama, from Meher and created Africatown, where some of their descendants still live. They spoke their native tongue, farmed using traditional African methods, and ran their own school. Nevertheless, Africatown has suffered from political and economic neglect for decades. Residents hope the ultimate discovery of the ship may bring some attention and prosperity to this unique place in our nation's history. I believe that the demand for reparations does honor to the ancestors regardless of whether reparations are achieved. Reparations is about repairing the image of the oppressed, speaking truth to power, reclaiming what was unjustly taken, and insisting on the right to self-determination. I'm honored to be a part of a movement that puts reparations for the oppressed at the center of its efforts. And with that, I'll turn over the mic to our first panelists. Thank you.
Good morning. I'm honored and humbled to have been invited to be here. Many people. I said I'm humbled and honored to be invited here because there are a lot of people in this room whose work and voice has been a guiding star for me, and I look forward to hearing more from them and everybody else, even more so because I am not a scholar of reparations per se, but perhaps some issues that surround it. So I'll offer some of my thoughts, but look forward more to hearing from others. Couple of things that I would like to say here, and even I would also want to particularly thank Robert and Saru, also personal friends, and when they say jump, I only say how high. So when they had this thing going here, I had to come. Robert in his opening remarks mentioned that reparations to some measure is a response to a remedy for a prescription for the wrong done in the past. And I think that's a very accurate statement. Having said that, I think it may be important for us to remember that while a disease, the diagnosis of the disease and the prescription for the disease are, of course, linked and stand on each other, but I would venture to say that there is almost an unavoidable dissonance between them two. A diagnosis can never quite capture the whole malady, the whole pain. A prescription cannot quite heal all the wounds, though still we have to move on. So I think that needs to be stated. Similarly, because the whole issue has been framed around the question of law and justice, and in a glib way, we almost use the two synonymously. I think it is also critical at any moment, but particularly when we are talking about such a serious issue where both are implicated, to keep in mind the very fraught, to say the least, relationship between the two. The law can never pretend to be law without holding the promise of justice, but law cannot quite be law if it achieves justice. There is always a determinate and a responsive element to the law, which have to coexist, but which never quite meet. And I think that's a dilemma, systemic, existential, and otherwise, that we will have to account for as we have this conversation. Last professory remark that I bring the question of colonialism to the fore, not as some distinct question, as some peripheral issue, but rather I would suggest, and I'm not alone in that, that colonialism, the now 525-year-old phenomena, modern colonialism I'm talking about, one has a mutually constitutive role with modernity as such in all aspects of it. Certainly modern law, certainly modern modes of knowledge production, certainly modern modalities of governance, and modern modalities of violence. And consequently, any particular issue that has been put on the table, be it the Atlantic triangular slave transportations or otherwise, I think it may be useful, perhaps even indispensable, to locate it within this larger and deeper canvas. Otherwise, we may miss out on something which is very vital to the particularity at hand. Having said that, I think we should be mindful, because the conference organizers have charged us, and rightly so, to think through some things. So I think some inherent and some situational limitations on that thinking need to be acknowledged in order to perhaps even give us license to think. Because I think most of us may agree, probably would agree, that we are living in strange times where almost all institutions and structures are in perpetual crises, but still somehow manage to totter along. Could it be primarily because of a failure to imagine alternatives? Most of us, for example, can imagine the end of the world. We can imagine the end of the planet, but we can't imagine the end of rule of capital. Back to the law and justice question before I turn to specifics. And the colonial canvas, I think, perhaps more than some other registers, brings it to the table, though by no means the only register. The gap, as I'm suggesting, almost unavoidable gap between law and justice. Because if we look at the operation of law, certainly for the last 524 years, that there appear to be always bodies and spaces which continue to lie in a legal and moral no man's land, as Denise de Silva has very evocatively put it, where law and justice always appear to find their spatial limit. Back to the reparation question, redress question, the hanging in the air questions, implicit questions are there. About what? To whom? By whom? When? Where? One of the things that we're back to the malady diagnosis and prescription metaphor, there's a difference between diagnosing a disease once it has run its course and diagnosing a disease when it is still continuing, perhaps even flowering, while transforming itself. So one question that I think we should be mindful is, are we talking about the past? Robert, in his introductory remarks, also underscored that question. Here, Faulkner may be very relevant, that in this case, most certainly, the past isn't over. It isn't even past. Because if colonialism is the macro question, the whole scaffolding and almost all building blocks are still in place. Most certainly, and often in transformed shapes, some weakened, some strengthened. So I think that is something that we have got to be mindful of, that we are talking about a past which is not a dead hand of the past. It is alive and kicking. And finally, if the drama that we are talking about, be it acts which are done and acts which are yet to, curtain has to be raised and is in play, is global in scope, then it stands to reason that the response to it has to be global in scope. And I'm mindful, as our Canadian friends have made a habit of, and I forgot to do it, to acknowledge that we are sitting here in a colonial settler society on land of other people having this conversation, that the American exceptionalism question and the American Constitution and American constitutional history being the lodestar for humanity, as it were, I think a very big question mark has to be put on that in order to even in any meaningful way address the issue at hand. So I'll just give you a very thumbnail example of one attempt of a global response to the colonialism question, which had built into it the redress, reparation, and transitional justice question, and how it fared and what we may learn from it for today. And here I'm taking my point of departure from the famous Afro-Asian conference in Bandung in 1954. The first time in the middle of decolonization, 29 countries and a host of other non-state actors also, representing at that time about 2/3 of humanity, met. And, there are lots written about it that you can go. I just want to focus on two propositions that they had a political committee and an economic committee. The political committee generated a focus on issues like sovereignty, non-interference, peaceful coexistence, non-alignment, decolonization, etc. And generally it is, even there are, two histories written about it. One, that the whole project was doomed from beginning and it was a disappointment in that. And then there's a parallel history suggesting, no, it was a great success and look at its progeny, etc. And there may be truths to both of those. I'm not here to debate that. But I want to focus on, really what came out and what can we learn. So, and they also had an economic committee, and I'll a little bit talk more about it because that's maybe more relevant in some ways to the reparation question. So the political committee's recommendations, I would venture, did have a very lasting impact in the sense that this is the first time, and in fact the very term Third world came into vogue after Bandung, the once colonized and then colonized found a unified voice for the first time in also formal halls of power. They did put equality and justice on the international legal and political agendas. It did produce a series of other similar steps ranging from the 58 First Conference of African Independent States, moving on to the trilateral conference in Havana, Latin America joining in, and then of course 1965 was supposed to be the 10th anniversary second conference, this time including Latin America and Algiers. And 2 nights before the conference, the government was overthrown, and the rest is history. The Economic Committee played it relatively safer, critiqued the Bretton Woods system and the economic structures of things, but decided to work within the system while asking for what I would call a robust global Keynesianism, Keynes on steroids, as it were, and on a global scale by way of questions of aid, technology transfer, debt relief, sovereignty over natural resources, etc., regulation of transnational corporations. And marginal success was found in terms of the UN system. UNCTAD was formed. Finally, all the way to 1974, when the new international economic order resolutions were adopted, permanent sovereignty on natural resources resolutions were adopted, some regulatory regimes, very incipient regimes for controlling transnational corporations was started. But that's when I would suggest, and partly because of those efforts, was triggered what I would always call the neoliberal counter-revolution. It is interesting that 1974 is the new international economic order resolution, and 1975 comes the Trilateral Commission report to suggest how the world should really be run. And by the way, one of the problems identified with it is that the system is suffering from not too little but too much democracy. So if what is happening today, you may want to go back to look at that besides Justice Powell's famous memo as to how to run things. So anyway, so what was lost, and how is it relevant to us? So one already said that, yeah, a voice was found, an agenda was expanded, a confidence was gained, contacts, tri-continental contacts were generated around a common agenda. But I think after that there were many things which have more a cautionary tale. The biggest one being, I think, that this was in a way a failure in sort of meta choices. By that I mean not the choice that do I go this way or do I go that way, but meta choice to open to see what the choices are. And 2 fatal choices that were made, perhaps as condition of the zone of possibilities as they saw it, that it was wholeheartedly bought into 2 lethal grammars of the time. One, the nation state, the sovereign nation state, and 2, developmentalism, and all that comes in its train, and this is not the time to sort of explore that. And so to the extent that these 2 foundational pieces of grammars of modernity were always already bought into, the possibility of then bringing down the house or building anew was foreclosed from the beginning. So I think where we stand today is it has to go back to that one would have to think if colonialism is the question then and decolonization is the agenda, then it has to start with decolonization of imagination. As it has been said, you can't destroy the master's house with the master's tools. And there's wisdom in those kinds of sayings and words. What are our limit horizons when we come to question of reparations, when we come to the question of redress, when we come to the question of relationship between law and justice? None of them gives us an easy answer. But as one said, easy answers are dime a dozen. The challenge is to ask interesting questions. At times when one is confronted with Tina, as I was reminded the other night, there is no alternative. I think we have to insist, as the World Social Forum did at Porto Alegre, another world is possible. But another world is possible only if one would not circumscribe the canvas itself, where it would put out of focus the animating forces which created the catastrophe in the first place. For one specific proposition, I leave you that at a minimum, we have to redefine what third world means. Where is it? What bodies? What spaces? And perhaps we could think about a first world as the transnational capital class, which is not in any one place. Perhaps the second world is the managers and enforcers and trainers of that system. The state apparatuses, the violence apparatuses, the educational and ideological apparatuses. And then you have a third world, which is again the exploited, the oppressed, the marginalized, the surplus populations, as it were, all over. Because I think that would change our view of who has to pay and who has to be paid and how the payment has to be done. Whether it is a check to be issued, or is it new structures to be created, both of governance and of economic interaction and of cultural development? Thank you.
All right. Okay. So, and the mic is on. Good morning, everyone. Good morning, and thank you to the organizers for welcoming us to this conference. I'm very happy to be here. My presentation today is part of my doctoral dissertation project, which is tentatively titled Reparative Reason, Redress and the Politics of Land Claims in Guyana. My inquiry today is part of my broader thinking about the international organizations within which reparatory justice for slavery is discussed. At this point, my writing is based on 2 summers of ethnographic research in Jamaica and Guyana, respectively, research visits to the International Court of Justice in The Hague, and attending meetings at the United Nations in Geneva. I will commence my year-long fieldwork in Guyana and with CARICOM, among other organizations, in September this year. So central to my concern today is the legal ambiguities in the language of the Durban Declaration documenting the United Nations World Conference Against Racism in Durban, South Africa in 2001. I will analyze the declaration's paragraph 13 in the context of Western European responses to CARICOM's reparation claim. I refer briefly here to 3 of such responses, namely a French and a British and a Danish response. To clarify, hold on, now I need to do one of these. No? It came. Oh, it's good. All right. To clarify, founded in 1973, CARICOM is a multi-government Caribbean community organization whose objective is to coordinate regional economic and development policies among its 15 member states and to support the operation of a regional single market. Their secretariat is in Georgetown, Guyana. I argue that both the Durban Declaration and Western European responses to reparation claims is articulated through a rhetoric of compassion. The crucial difference between the two, however, is that despite the ambiguous language of the Durban Declaration, it categorized slavery in legal terms a crime against humanity. This categorization, I believed, helped to propel the formation of the CARICOM Reparations Commission to frame their case for reparatory justice as a legal project. Europe's response to the reparation claims, on the other hand, is focused on their acknowledgement of a moral responsibility for historical injustices, while a legal and a material responsibility for historical injustices remains unaddressed. So far, the CARICOM Reparations Commission has tried to negotiate with Western European nation states in letter writing before taking their reparation claims to court, presumably to the ICJ. I will outline why another option may make sense, which would be to ask for legal clarification of UN's categorization of slavery as a crime against humanity, and to request an advisory opinion from the ICJ through the UN Security Council. Despite numerous problems with the UN as a platform for political mobilization, it has, for better or worse, shown a commitment to connecting current socioeconomic inequality in the global south to the history of the transatlantic slave trade, even if it hasn't specified the legal implications of this commitment. And so I structure my presentation in the following way. First, I will briefly situate CARICOM's reparatory justice program. Second, I will discuss the Durban Declaration paragraph 13. And third, I will give 3 examples of Western European responses to historical injustices. And finally, I will conclude with a few comments on the role of the UN for the CARICOM claim. Okay, so to begin. Clean up the colonial mess, said the chair of the CARICOM Reparations Commission, Sir Hilary Beckles, speaking to former European colonial powers in October 2017, during the inauguration of the Center for Reparations Research at the University of the West Indies in Kingston, Jamaica. 4 years earlier, in 2013, the multi-state Caribbean community organization CARICOM responded to a growing popular Caribbean sentiment. The organization argued that the moral, legal, and political response of Western European powers to native genocides and the enslavement of African peoples in the region had been inadequate. CARICOM approved a reparatory justice program to demand that a Caribbean case for reparations from Western European nation states be heard before the International Court of Justice in The Hague. National reparations commissions were established across countries in the Caribbean. The commissions were tasked with preparing a lawsuit for redress by gathering historical information from each claiming state and outlining evidence of contemporary racial discrimination resulting from transatlantic slavery and the genocide of indigenous peoples. And while the material and practical implications of the reparatory justice program are beyond the remits of this presentation, I would like to briefly list them here. Okay, they consist of a demand for 1, a full formal apology. 2, repatriation. 3, indigenous peoples rehabilitation program. 4, heritage institutions. 5, attention to a Caribbean public health crisis. 6, eradicating illiteracy. 7, an African knowledge education program. 8, psychological rehabilitation. 9, technology access. And 10, debt cancellation. One way to frame a very short history of CARICOM's reparatory justice program is to begin almost 2 decades ago in Durban, South Africa. During this conference, Caribbean and African states attempted to generate a conversation about reparatory justice for colonialism using the UN conference as their platform. The participating African UN member states were divided on the Caribbean delegation's proposal to include reparations for historical injustices as a human right on the agenda. Western European and North American contingencies united in their worry that a discussion about reparations would have politically binding effects and ultimately objected to the proposal. Reparations were not discussed as an official agenda item during the event, and the Caribbean delegation left the event disenchanted. Yet momentum for a unified Caribbean position on redress for historical injustices had begun. While the conference did not produce a politically binding outcome, paragraph 13 in particular is written in a language that is at the same time ambiguous, but nevertheless supportive of what would later become the CARICOM Reparations Commission legal case for the reparatory justice case. So paragraph 13 of the declaration says, okay, we acknowledge that slavery and the slave trade, including the transatlantic slave trade, were appalling tragedies in the history of humanity, not only because of their abhorrent barbarism, but also in terms of their magnitude, organized nature, and especially their negation of the essence of the victims, and further acknowledge that slavery and the slave trade are a crime against humanity and should always have been so, especially the transatlantic slave trade, and are among the major sources of manifestations of racism, racial discrimination, xenophobia, and related intolerance that Africans and people of African descent, Asians and people of Asian descent, and indigenous peoples were victims of these acts and continue to be victims of their consequences. Okay, so there are several troubling points with this paragraph, and I will focus on the part in italics. By underscoring that slavery and the slave trade are crimes against humanity, the authors indicate that a similar act in the present would be considered a crime subject to prosecution. By stating that slavery and the slave trade should have always been considered a crime against humanity, they acknowledge that historically this has not been the case. On the other hand, the Declaration delivers a rhetoric of compassion. On the one hand, the Declaration delivers a rhetoric of compassion in the form of regret and expresses moral concern for the victims of enslavement, the slave trade, and their descendants. By acknowledging the harms it has imposed on generations of descendants of enslaved, the Declaration takes a moral stance on slavery in the past on behalf of the international human rights community represented here by the UN in the present. On the other hand, the Declaration does not clarify whether an act that was not considered a crime against humanity at the time can or should be considered a crime today. And in the case of the latter, what are the legal implications of this consideration? I want to suggest that to categorize transatlantic slavery a crime against humanity without specifying the role of retroactive or retrospective legislation renders the categorization legally ambiguous. While the criminalization of contemporary slavery suggests a desire to avoid repeating faults of the past in the future, the distinction between retroactive and retrospective legislation is blurred. The Durban Declaration's condemnation of transatlantic slavery as a crime against humanity is thus a double-edged sword. While providing a language for categorizing slavery as a violation of international law, it does not specify the legal implications of this terminology. And in this regard, the document, thank you, to me exemplifies Laurent Bellon's idea of an object of attachment, which from a legal point of view can only disappoint. The rhetoric of compassion, coupled with the ambiguous legal language of the Durban Declaration, reverberate in Western European public responses to claims for reparations in the Caribbean. As a number of scholars have argued, European states sometimes willingly embrace and acknowledge responsibility for historical injustices. Their engagement, however, primarily starts and ends with the rhetorics of compassion, with a moral concern for historical injustices. Repudiating the past has become common language in Western European nation-states' public response to questions regarding their history of colonialism and enslavement. In the following, we will see three examples of these responses, beginning with France, and here in particular, my analysis echoes my colleague Howard's work on Germany. During a tour of the French Antilles in May 2015, François Hollande became the second French president to visit Haiti since its independence in 1804. During his official speech, Hollande said, France today wants to help in the development of Haiti. We believe in Haiti because you have considerable opportunity. In a newspaper source, Hollande is further cited for having said, "We can't change history, but we can change the future." And he further acknowledged that there is a moral debt that exists. Hollande's rhetoric of compassion is curious, but it's not coincidental. France appears to be in the moral vanguard of taking responsibility for its past in the president's acknowledgement that a moral debt from France to Haiti exists. Hollande even expresses his interest in helping Haiti. Meanwhile, in his slippery response, he does not clarify what a moral debt entails. He neglects to address any material dimensions of this debt, nor does he address the history of slavery as a violation of international law. A similar rhetoric occurred when in September 2015, David Cameron visited Jamaica for the first time as the British Prime Minister. Confronted with questions about claims for reparations by the then Jamaican Prime Minister Portia Miller Simpson Miller. I got it. Okay. Sorry. Cameron assured her that the British government abhorred slavery and indeed had passed the Modern Slavery Act to tackle human trafficking today. Note the word abhorrence in this quotation. Abhorrence in this context signals the British government's condemnation of and moral outrage towards slavery. Cameron is willing to condemn slavery in the past, insofar as it enables him to focus on his envision of a morally improved present and future of the British nation state. Again, the material implications and the legal dimensions of the reparation claims remains unaddressed. In a slightly different context, but nevertheless similar, and more recently, in November 2017, articles began to circulate which said in the header, "Denmark apologizes for slavery." The occasion was the Danish Foreign Minister Anders Samuelsen's visit to Ghana, during which he lamented, "We share a dark history of the slave trade, a shameful, unforgettable part of Danish history. Nothing can justify it." The minister embraced guilt for historical injustices and condemned past wrongs, which he called the dark history of the slave trade. Importantly, however, one could summon that the minister's acknowledgement of Denmark's participation in the transatlantic slave trade would entail that precisely because their engagement is quote-unquote unjustifiable, neither an apology nor a politics of material repair could ever justify the quote-unquote shameful, unforgettable past of Danish history. Contrary to the title of the article circulating online, in my interpretation, the wording of the Prime Minister indicate that a political apology is redundant. These three examples demonstrate how these ministers apply strategies of recognizing colonial injustices and morally embrace guilt for past wrongs, while reserving primary attention to the future goodwill of the former colonizing nations and their commitment to improve. The material dimensions of reparation claims for historical injustice remain unaddressed. I speculate that these governments' written responses to the CARICOM Reparations Commission's letters in similar ways have expressed their moral concern for historical injustices in the past, while disavowing the material aspects of state responsibilities for these injustices. And so before I close off, I want to point our attention to a few complicating circumstances in international law, very briefly. While there are no statutory limitations on international law violations, such as crimes against humanity, the undergirding sentiment of the minister's responses is the idea expressed by Jeremy Waldron that, quote, historical injustices have been superseded, unquote. In other words, the crimes of slavery happened too far in the past to have any reasonable effect on the present and thus cannot be prosecuted in a court today. And furthermore, in a Q&A last year at the ICJ, Judge Antonio Augusto Cansado Trindade claimed that contrary to public interest in, quote, opening up, unquote, the past, judges in international courts want to, quote, draw curtains closed, unquote, on legal questions about reparations for colonial harms. According to Trindade, there is a sense in which international jurisprudence, similarly to statutory limitations, push against reparation claims for slavery. This tendency among the judges corresponds to the Western European nation states who also evade the legal and material implications of Caribbean reparation claims by overemphasizing their moral concern for historical injustices. So the Durban Declaration is an ambiguous document that ultimately does not take any legally binding stance on categorizing slavery and the slave trade as a crime against humanity. Nevertheless, the Durban Conference marks, I believe, a crucial moment in the configuration of a distinct human rights concern for people of African descent based on a history of slavery and the slave trade, highlighted here by their categorization of slavery and the slave trade as a crime against humanity. The institutional infrastructure made available by the UN, including here the United Nations Working Group of Experts on People of African Descent that was established in 2002, and the United Nations inauguration of the International Decade for People of African Descent from 2015 to 2024, so the institutional infrastructures enable an organizational space for the continued discussion about reparations for slavery. Most recently, the regional meeting of the International Decade for People of African Descent in Geneva allocated a full afternoon session chaired by Director of the Center for Reparations Research, Professor Irene Shepard, to discuss reparatory justice for slavery and the slave trade. The UN has no enforceable mechanisms to make European states stand before the ICJ in a legal dispute about reparatory justice in the Caribbean. The jurisdiction of the court is based on the consent of states. Exemplified here with the Durban Declaration, however ambiguous it might be, the UN represents a real and discursive mechanism of applying pressure on European member states to address contemporary issues of racial inequality and their relation to the history of slavery. UN's organizational support of human rights for people of African descent and their acknowledgement of slavery as a crime against humanity provide the possibility of pushing the UN further. So exploring this legal avenue of the UN could imply or would imply that the CARICOM Reparations Commission would hold the UN accountable for specifying the legal implications of categorizing slavery a crime against humanity, and furthermore could extend this push to file a request with the UN Security Council for an advisory opinion from the ICJ. That's what I had. Thank you.
Okay, how do I? Can everyone hear me? Yes, okay. Thank you again for the invitation to this conference. It's really wonderful to be here, and it's a really exciting panel and a really exciting audience, and I feel really privileged to be here, so thank you. This paper is based upon 2 summers of preliminary research, and I will conduct 1 year to 18 months of long-term research in both Germany and Namibia starting in September of this year. My focus in this particular paper will be on the German government's response to an intergenerational reparations claim that has been brought in New York City in a Southern District Court by a diasporic group of descendants of Namibian Herero and Nama genocide victims. So to begin, on the 13th of October of last year, I attended for the second time a crowded pre-trial conference in the New York Southern District Court. The question under consideration for the judge was, and continues to be, whether a trial by jury should go ahead for what has been termed by the United Nations the first genocide of the 20th century. Facing the judge and alongside the 3 named plaintiffs sat a delegation of approximately 50 descendants of genocide victims and their lawyer, who recited the history of the Herero and Nama genocide and its impact upon contemporary Namibia. Many in the large delegation from Namibia, who you can see here outside the courtroom, had saved large sums selling household items in order to be in attendance. They had come to face those they accuse of committing and then refusing to redress a genocide that uprooted and that continues to uproot their lives and their lands. In the seat of the accused, however, there sat no lawyer and no defendant. The accused had, until eventually being served a US Department of State summons, and this took a very long time, not acknowledged the existence of the case, and continues to be unwilling to negotiate with the descendants of the victims. And in the last pre-trial conference that I attended, the German government is now claiming sovereign immunity. Yet Germany's arguments go beyond the technicalities of sovereign immunity in various domestic and international courts. It also argues more broadly that it has no responsibility, whether legally sanctioned or not, to provide material remedy to the descendants of Herero and Nama genocide victims. At the very same time as this denial of the logic of reparatory justice, however, official negotiations are today taking place between the German and the Namibian governments over the wording of an apology for what the German government is calling the historical atrocities that took place in 1904, explicitly avoiding the term genocide. A large-scale initiative is also being launched in which institutions and regions all over Germany will be twinned with sites in Namibia in order to foster what is termed the moral and historic relationship between the two countries. The coalition agreement of the new German government in fact explicitly mentions investing in cultural programs that it will foster what, as Robert Wesley told us at the beginning, Germans call Vergangenheitsbewältigung, the process of coming to terms with the past in the context of German colonialism. And this is a recent exhibition, it says German colonialism, that was at the German Historical Museum in Berlin. From one perspective, therefore, and as the Guardian newspaper has put it, Germany is a lesson to other European powers who are somewhat more reticent about the fact of having violently dominated the entire globe. From another perspective, the country that provided widespread reparations for Jewish Holocaust victims and that has strict Holocaust, genocide denial laws seems not to be practicing what it preaches when it comes to a genocide that it committed other than the Holocaust. I'm just going to very briefly read the wording of the beginning of the class action claim so you can see what the plaintiffs are asking for. So it reads, plaintiffs bring this action on behalf of all of the Herero and Nama peoples for damages resulting from the horrific genocide and unlawful taking of property in violation of international law by the German colonial authorities during the 1885 to 1909 period in what was formerly known as Southwest Africa, now Namibia. Plaintiffs also bring this action to, among other things, enjoin and restrain the Federal Republic of Germany from continuing to exclude plaintiffs and other lawful representatives of the Over-Herero and Nama people from participation in discussions and negotiations regarding the subject matter of this complaint. So that second part has to do with the fact that the German government is negotiating with the Namibian government, but the descendants of the victims are not involved in the negotiations. And there are complex reasons for that. So this case, I believe, highlights a number of deeply sensitive, complex, and often contradictory elements of European memory culture and also European legal culture. The aim of this short presentation is to pose one overarching question. How and why does the German government engage in a certain kind of historical reckoning concerning their first genocide, while being so unwilling to negotiate with the descendants of the victims and refusing to recognize the atrocities committed against the Herero and Nama with the legal category genocide? And there are echoes here with the examples that Anna mentioned throughout Western Europe. The German case has its own complexities. The Herero and Nama genocide was officially recognized by the United Nations Whitaker Report as the first genocide of the 20th century in 1984, and yet knowledge of it has until recently been very minimal, including in both Germany and in Namibia. I'm going to provide an extremely brief history, extremely brief. But in 1884, the new German nation-state hosted the Berlin Conference, which initiated the phase of late imperialism known as the Scramble for Africa. Germany colonized parts of Africa, China, and throughout the Pacific Islands. So this is the German colonial empire. Southwest Africa is in Southwest Africa, just above present-day South Africa. As writers such as Mahmoud Mamdani and Siva Gruvogi tell us, the settlers who moved to the settler colony of German Southwest Africa became increasingly frustrated with having to negotiate for the most valuable land of those who they saw as savages, the Herero people in particular. As their impatience grew and they became more forthright in their occupations of Herero land, the Herero began to rebel, and the Nama, traditionally enemies of the Herero, later joined. In response to this rebellion, a newly recruited German general issued 2 orders to his troops that have become known as extermination orders. They called for the extermination of the entirety of the Herero and the Nama peoples. 1/3 of the Herero and Nama population were immediately killed, yet many managed to flee. And I'm sorry for the graphic detail of this description, but I think it's important. The Germans poisoned water holes and rounded up and placed the majority of the survivors in camps styled on British concentration camps for the Boer Wars in the cities of Swakopmund and Luderitz, which are on the coast. The majority were starved to death in these camps. So I'm going to show a couple of quite graphic images. This is an image of captured Herero prisoners with German soldiers, which I actually found in an archive in Windhoek when I was in Namibia, and these things are kind of hard to find in Namibia itself, but you can find them. And this is an image of a basic work camp upon which a German Lutheran church is today built for the German Namibian community who continue to live in Namibia. So approximately 80% of the Herero people were wiped out and more than half of the Nama. That's the German church. Many of the Herero who managed to flee ended up in South Africa and Botswana, and today there is also a significant diaspora in the United States, and that's why, partly why this issue can be brought in the United States. So this is a diasporic group, and obviously we've seen these kinds of atrocities in many settler colonial situations, so this is not unique. Many of the officials involved in the administration of the Namibian genocide were too involved in the administration of the Armenian genocide, and a number of their children were involved in the administration of the Holocaust. And the links between this genocide and the Holocaust have been documented in a number of books. The genocide left white German settlers in continued ownership of Herero and Nama lands. German settler colonialism followed by the rule of South African apartheid and now the continuing white ownership of the most valuable land has meant that, to quote Herero paramount chief Vekoi Roko, our land, open quote, our land has become the private property of the descendants of white settlers, end quote. So as the first speaker mentioned, and I think it's really important, this is not just a question of the past, this has very serious ongoing effects in contemporary Namibia. So rather than asking how and why this genocide has been forgotten in contemporary Europe, which is a question we could ask, but now quite a lot of people are talking about it, especially in Germany, I rather want to ask after the basis upon which the German government is refusing to acknowledge the possibility of legal responsibility for the descendants of the victims of this genocide, while simultaneously investing in coming to terms with what it calls the historical atrocities that it committed in Namibia. And this dualism is made very clear by German government officials themselves, who say in a number of interviews, public interviews, we do not start from the basis that this is a legal obligation, but rather a moral and historic obligation. There is a special relationship between Germany and Namibia for moral and historic reasons. I think there's a lot to unpack here, but we don't have time for that. So. Reparations activists are keenly aware of this, and they have informed me again and again, I mean, I would include myself in that category, but that, oh, no, that's not part of my slide. Quote, the government wants to make it about history, but not about law, and this is not enough, end quote. So why is the law so radically separated from morality and history for the German state and for the rest of Western Europe, as Anna mentioned? Why does it seem so much easier for the government to invest in initiatives that deal with the history of these atrocities rather than to recognize this case as the UN have as a genocide and to invest in initiating a process of legal remedy as took place in the case of the Holocaust? So I will attempt to pose 3 possible answers to this question, and these are not exhaustive answers, obviously. So the first is the complex and often opaque and flimsy frameworks that international law provides in order to deal with cases such as this. I'm sure other people will talk about this. And with colonial era reparation claims more generally. In the case of the Herero, many argue that it does not make sense in international law to accuse any government of the crime of genocide before the 1948 Genocide Conventions. Such writers as David Bargano have argued this. Given that the legal term genocide did not exist at the time of the colonial period, it is argued that Germany has no need to speak of this term in law. 2 years ago, however, German lawmakers recognized the Armenian genocide as a genocide which took place long before the genocide conventions. So that argument doesn't quite work. And this is a recent satirical cartoon, or I think you can see it, or it's from 2015. That's Angela Merkel recognizing the Armenian genocide, hammering a board into the ground that says the massacre of the Armenians was genocide, and then behind her is the ghost of the Namibian genocide. So another argument, therefore, is that, so this doesn't quite stand up to scrutiny. So another argument, therefore, is that there is something of a violent dualism being enacted throughout Europe between redress of the genocides, and here we must, of course, speak in the plural, of the European colonial period and other genocidal crimes, the former requiring merely historical and moral reflection, the latter requiring legal redress. This dualism is seen by the Herero and Nama, and one cannot help but see the point as a highly racialized and racist separation. So we often assume that arguments concerning the lack of responsibility for the colonial era in Europe have to do with temporality, that it is simply easier for European states to ignore events that happened outside of the living memory of most, if not all, Europeans. Yet this does not make sense when we consider the vigorous Western European response to the Armenian genocide. So a third possible answer to the posing of a separation between law and history has to do with money in the context of an intergenerational legal claim. Germany does not want to pay, this argument goes, especially because there are no living survivors. And this argument makes sense not because of the amount of money. Germany is already paying large amounts to Namibia in the form of development aid. In fact, Namibia is the #1 recipient of German development aid per capita. It is rather that the moment this money would become legally sanctioned reparations, it would, I believe, be the first time in which reparations will have been paid by a European nation state for a colonial era crime in which there are no living survivors. And as a German politician has argued, this may cause a domino effect throughout Europe, setting a legal precedent. So it is not, I don't think it's the sums of money that are feared or even the fact of payment that is feared, but rather what is feared is the logic of reparatory justice in the context of colonial era claims for atrocities in which there are no living survivors. So it's again how far back, the question of how far back do you go, and they're terrified, to put it bluntly. So I'm just analyzing the situation, but Herero and Nama activists are themselves launching a trenchant intergenerational critique, young and old, of the German and wider European desire to concentrate solely on historical reflection rather than on legal analysis. As Katwa, one of the listed plaintiffs in the New York case and head of the Association of the Over Herero Genocide in the USA, informed me in an interview, it is not up to the felon to determine his or her punishment. I think this is kind of the crux of everything. But that's something else we can discuss. Likewise, the slogan, "There is no statute of limitations for genocide," which is what this sign says. I think the German meaning is slightly different, but it has that meaning. Has become something of a means for descendants of genocide victims, such as this man Israel, to catch out the German government on their prevarication between historical and legal responsibility. So Herero and Nama reparations activists primarily use legal concepts in order to make their points heard. Moreover, they articulate themselves not as descendants of victims, but as victims themselves. So when asked, as they often are over and over again in public debates, whether descendants of victims have the right to seek redress as descendants of victims, most Herero Nama interlocutors will answer very similarly, which is, quote, "We are the victims. We still suffer at the hands of the Germans," end quote. So the question of the category of the victim is important here too. So to conclude, we are probably left here with more questions than answers, and this can't be a bad thing given the complexity of these discussions. On the legal side of things, there's a lot more to say. I'm not a lawyer. But the legal history of the Herero-Nama reparations case is fascinating, and I would highly recommend Jeremy Sarkin's book on Herero reparations. So I want to leave us with a metaphor that has stayed with me throughout my research so far, and that is inspired by an article by anthropologist Nadia Abu al-Hajj. The Roman god Janus had two faces. The term Janus faced has come to mean hypocrisy, to say one thing while doing another. Yet the term has lost its emphasis on temporality, that from one perspective the god Janus looked to the future, but from the other he or she looked to the past. Throughout my research so far, Herero and Nama genocide victims have encountered a Germany that on the one hand is steadfastly concerned with looking to the past and coming to terms with the history of genocidal atrocity. So there's no point pretending that Germany is completely ignorant of these things. And yet, on the other hand, is unwilling to look backwards when it comes to the law in the context of colonial crime, that refuses to use the term genocide, and that is unwilling to take material responsibility for the descendants of genocide victims, other than the Holocaust. Such scholars as Henning Melber and Reinhard Köstler have spoken, who are German scholars, have spoken in different terms of what I think is the Janus face that plagues this case. And the Herero and Nama have to deal with this every day, and perhaps the question is how to get the German state or any European state to show both of its faces at the same time. And this will not be an easy task in the coming weeks, months, and years for the Herero and Nama, and because this fight is not ending for them. And I think it shows, moreover, that we might want to proceed with a little nuance when approaching the complex object of what is known as the German model of dealing with past atrocity.
Hi everyone, my name is Caleb Lauer. I'm a PhD student at the University of Waterloo in Ontario, also with the Balsillie School of International Affairs. Thank you so much for having me here, especially thanks to Professor Wesley, Professor Matam Bonanzo, Jacob, Alexandria, and Andrea, all the people that I've been interacting with. I appreciate all your efforts. I think everyone appreciates your efforts, and thanks so much for having me. These presentations have been fascinating, and what I have to say fits in a similar way, fits in a way with different aspects of each of the presentations. My broad topic is reconciliation in Canada, and as many of you will know, Canada is consumed at the moment with this notion of reconciliation, especially in the aftermath, if that's the right word, of the release, the release of the final report of the Truth and Reconciliation Commission of Canada. The final report was published in 2015 with a whole host of recommendations. And that commission of inquiry was basically, the job was to write the history of the residential school system in Canada, which, as many of you will know, was the primary means by which the Canadian state, the Canadian government, tried to obliterate the culture of Indigenous peoples in Canada by separating children from their parents, from their home, outlawing their language, outlawing their religion, and basically turning Indigenous children white and Christian. So the Commission released its report a couple of years ago, and the Canadian government of Justin Trudeau, which came into power shortly after, embraced the findings of this commission and embraced the recommendations that this commission put forward, which was in stark contrast to the previous government led by Stephen Harper, who many of you will know was of a very different opinion of things, colonial, let's say. I should say he offered an apology to Canada's Indigenous peoples, which at the time was taken as a very positive step and was, taken in good faith, but that was disappointed very quickly as that was basically all he did. So that's the general sort of topic that I'm dealing with, and what I'm doing, this is all part of my dissertation research, which is in fairly preliminary stages. I'm trying to understand the relationship between reconciliation in Canada and sovereignty, this notion of sovereignty, which is not often discussed at a theoretical level, at a scholarly level, and it's certainly not discussed in the mainstream public debate about what reconciliation is. And I'm basically, through the work I'm doing now, as I said, it's preliminary, I'm trying to get to grips with what this relationship is. I came to this problem of this notion that reconciliation is somehow related to sovereignty circuitously, basically by noticing that in the Canadian discourse, the Canadian government discourse of reconciliation, the Truth and Reconciliation Commission recommendations, and in the UNDRIP, which is the UN Declaration on the Rights of Indigenous Peoples, which the Canadian government has adopted as a framework for reconciliation. In none of these things is there any provisions for land return as redress for the colonial injustices suffered by Indigenous peoples. And I found this interesting because, as many of you will know, in Canada and other colonial contexts, this is one of the main sort of demands of Indigenous groups, that if redress is to be meaningful, if reconciliation is to be meaningful, it should include to some degree land return, because I don't know if many people here be familiar with it, but there's a fairly well-known article in decolonizing, in the decolonization literature that's called "Decolonization is Not a Metaphor." And it basically makes the argument that we can talk about social justice and make a lot of nice noises as much as we want, but unless we are talking about land return, we are not talking about decolonization. Decolonization is something fundamentally different than other forms of social justice, and that fundamental difference is land must be returned. So in none of these things, mechanisms, institutions, discourses, is there provisions for land return, and I found this, interesting. Many people here will know that there is an empirical historical story as to why land return is not included in things like the UNDRIP or in the Canadian government's approach to reconciliation. I won't go through that whole story, but I want to take some analytical points from that story and make three main points. The first is that although the Canadian government, the current Canadian government, is committed to reconciliation, it has said it's committed to reconciliation, and while there have been redress measures enacted or offered, the Canadian government is using the term reconciliation in an equivocal way, and this equivocation is very interesting and problematic for me. It's interesting at the level of, just discourse analysis, and it's problematic at for me at least, an ethical level. It's a sleight of hand, in a sense, that I find very troubling. We have this sense of what reconciliation, the term, connotes, which is something like social justice, or social healing, social justice, this type of thing. But the Canadian government, despite framing its reconciliation policy in this world of social healing, et cetera, it means something very, very different. And it's interesting and, as I say, problematic equivocation. And it is directly related to Canadian sovereignty, the question of Canadian sovereignty. The second point I want to make is that the field of transitional justice as a scholarly field, not so much broadly, but in the particular attempts of scholars to adapt transitional justice theory and practice to the Canadian case, falls short. There is something missing in the field and practice of transitional justice that leaves it poorly equipped to address this particular problem of how reconciliation in Canada is connected deeply to a question of Canadian sovereignty. And the third point is and I'm having trouble articulating this, and hopefully some of our conversations will help me work my way through this, but there seems to me to be a category of things, and in that category of things I would include the Canadian government discourse of reconciliation, the field of transitional justice, the UNDRIP, and the Canadian Truth and Reconciliation Commission, that are relatable to each other because they each have an elephant in the room. And each of these elephants in the room are related to each other. They're siblings. And the surname of these elephants is sovereignty. There is some sort of sovereign elephant in the room in each of these particular things. And we can categorize these things by virtue of the genetic relationship between between these sovereign elephants in the room. And I find that interesting, to use a completely banal word, but salient in a sense, and it's suggestive of something, and I'm not quite there in figuring out what that is. So those are the three main points I want to leave you with. I'm going to work through them each and elaborate them. And I want to begin with this notion that the Canadian government is using reconciliation in an equivocal way. You know, as I said at the start, reconciliation is the buzzword in Canadian politics these days. 20 years ago, it was something to do with the French-English divide. You know, there's been many iterations of what's troubling Canada over the years. And these days, especially for the last 5 years, the word is reconciliation. At the public level, at the mainstream level, at the, you know, the walking down the street level, reconciliation is a very unproblematic thing. Most people, most non-Indigenous peoples in Canada are very, they like the term, right? And that's, you know, in a weird way problematic. And, you know, it's become a cliche, but reconciliation is about white people feeling bad so that they can feel good, right? Like that's sort of, that's the mood, right? And the problem is that that's not really noticed as problematic in mainstream society, right? So it's a winning topic. Anybody that is on the reconciliation bandwagon wins, right? And so the Canadian government, what it's doing is that it's getting on that bandwagon. It's saying a lot of nice things. It's making the right noises. And it's very happy for people to presume that what it's doing in terms of reconciliation is that. You know, it's sort of the official version of people feeling bad so they can feel good. But when you look I mean, you don't even have to look carefully, you just have to read it. When you read the policy statements of the Canadian government, you realize that they're doing something very, very different. And they're using the term reconciliation in a very specific way. And that way is reconciliation is the objective of reconciliation is to reconcile Aboriginal title or Indigenous land claims or Indigenous claims to sovereignty with Crown sovereignty, right? And this problem of how do we reconcile Aboriginal title or Indigenous claims to sovereignty with Crown sovereignty, which is, in the Canadian context, the Crown means the Canadian state. How do we reconcile that? Is not a problem connected to the Truth and Reconciliation Commission findings. It is not a problem connected to the history of residential schools in Canada. It is not a problem connected to what the mainstream generally takes the problem of reconciliation to be. It is language directly lifted from a set of Canadian Supreme Court rulings from the 1990s. As I don't know if people will be familiar with this, but the Canadian Constitution was repatriated in 1982, which basically means that we made it our own, and we took it back from the UK, from the British Crown. And as part of that repatriation, the Canadian Constitution includes Section 35, which is basically the section of the Canadian Constitution that protects Aboriginal and Indigenous rights. The Supreme Court, these cases based on this section, made their way to the Supreme Court by the 90s, and in the 90s there was a series of rulings. And in various ways, the Supreme Court basically articulated that Section 35 is an imperative to reconcile Aboriginal title with Crown sovereignty. And if you're the Crown, which is, you know, that's where the power is in Canada, you're not talking about an equal reconciliation between Aboriginal title and Crown sovereignty. You are talking about a subordination of, you know, all Indigenous claims to Crown sovereignty at the apex. So this is what reconciliation is for the Canadian government. If you look at what they say, every time they use the word reconciliation, despite the rhetorical frames that they put around it in terms of social healing, coming to terms with the past, et cetera, they are talking about reconciling Indigenous claims with Crown sovereignty. And for those of you who are, you know, interested in the a little bit more historical detail, it was Justin Trudeau's father, Pierre, who I hope some of you remember, I do, who was the prime minister at the time when the Constitution was repatriated. He is, in a sense, the author, or he has he can stake a claim on introducing Section 35 into Canadian constitutional law. The Trudeau government is not only using the language of the Supreme Court rulings to, give the foundation for its policy of reconciliation, it wants to use Section 35 of the Constitution, which was essentially a product of Trudeau the father, to be the basis for all reconciliation in the future, which is why the Canadian government's approach to reconciliation is called the recognition of rights approach, which is basically saying Section 35 of the Constitution is going to be the source, the epicenter of all reconciliation efforts in Canada. It's interesting at a political level because it's a bit of a dynasty-making effort, that Justin the son is going to realize the potential of what Trudeau the father introduced into Canadian constitutional law. So that's how the equivocation is working. So what? Why is that significant? For me, at a basic citizen level, I find it interesting that nobody's talking about that, right? It's not unknown, it's not easy, it's not difficult to find this out. Most Indigenous peoples will tell you that they have noticed this, of course, but it's not talked about in the news, it's not talked about in the sort of the public commentary on things. There's no real sense that this sleight of hand, as I mentioned, this equivocation, is actually an issue, and I find that completely bewildering. I don't quite understand how that can be. To be more specific, I'll just give you two examples as to why. Just two examples can sort of stand in for a whole set of other implications. The first is this attention to language. We're talking about equivocation, and we're talking about meaning shifting, et cetera, et cetera. Once you sort of notice that that's happening, I at least tend to become skeptical about all the ways that language is being used by the Canadian government, which is a pretty healthy thing. But in particular, the phrase nation-to-nation relationship stands out. The Canadian government is, The Canadian government is very keen on promoting what it calls a nation-to-nation relationship with Indigenous nations, Crown Indigenous relations. Once you realize that the entire purpose of the Canadian government's reconciliation discourse is to subordinate Indigenous claims to sovereignty to Crown sovereignty, the whole notion of nation-to-nation becomes something at least euphemistic, if not downright condescending. It's essentially a joke. And that sort of problem of euphemism and condescension can be found throughout the Canadian government's discourse. The second thing that that I find significant is that this assertion of sovereignty that the Canadian government is participating in is not happening in a vacuum. There is a reason, and there is a counterpart to whom the Canadian government is doing this. And the basic fact that the Canadian government is exercising itself, is going to such great efforts to reassert sovereignty, right, should alert us to the fact that there is a contestation of sovereignty happening. There are groups on the ground who are saying, we reject and we dispute and we contest this notion of sovereignty. So for me at least, that's the key thing, is that the sovereignty contestation that's the assertion of sovereignty that's happening in the Canadian discourse of reconciliation should alert us to the fact that there is a sovereign contestation happening. And that contestation is important, I think, in two ways. One is there are groups that are rejecting the Canadian notion of sovereignty, as they always have, and that sort of points out the fact that the notion of Canadian sovereignty has always been contingent, has always been a construct that has been asserted on other people. And they have had that visited upon them through pure force, basically. The other thing is that the mainstream notion of Canadian sovereignty is accepted as this universal given by most of society through a similar mechanism. What is a contingent notion of sovereignty is basically delivered to the Canadian populace in such an expert way that nobody even notices for a moment that this may not be a universal, taken for granted type of thing. This is a very problematic thing. So there's two things happening. One is it's being asserted on people who are resisting, and it's being constructed in a way that its contingency is made invisible for most of the population. So I think I've just got a couple minutes left. I'll say the two other points I'll say real quick. The second of my main points is that transitional justice is poorly equipped to deal with this. And it's poorly equipped to theorize the problem of sovereignty as it pertains to the discourse of reconciliation in Canada for three reasons. The first is that reconciliation in Canada is about something different than what transitional justice generally or traditionally thinks of as reconciliation. There's components of that reconciliation, but the main problem is something that is outside the field. The second point I'll make, and I'm a bit nervous to make this point in a room full of legal scholars, but transitional justice is a law-based program focused on justice. It's focused on rights, et cetera, et cetera. And the thing that I'm talking about here, we need to theorize at a much more raw level of pure power relations. Law, justice, rights, et cetera, are a bit too civilized, to use a really problematic word, for this type of thing, right? We are talking about pure power relations. We are talking about the raw assertion of force of one group upon another. And I don't think transitional justice is there yet to deal with that kind of thing. Also, transitional justice, as many of you know, this is almost a cliche critique, but it has an inherent state strengthening sort of bias to it, which is part of the problem in this. And the final point, just to sort of reiterate the third point that I want to leave you with as a conclusion, is that these things, the Canadian Government Discourse of Reconciliation, Transitional Justice, the UNDRIP, the Truth and Reconciliation Commission, are, just as I said about transitional justice, they share this focus on law, rights, and justice. And that obscures, I think, how the problem of redress needs to get a little bit deeper in a general sense. We need to get to the level of power relations. So I'll leave it at that. And sort of as the basic sort of conclusion of things, the discourse of reconciliation in Canada is connected to sovereignty, and sovereignty is a function of privilege. If we want to understand the real issue of reconciliation in Canada, we have to delve into this question of privilege and who's privileged by what sovereignty, essentially. So thanks very much for your time.
Professor Wesley and friends, thanks for giving me the opportunity to speak. As I begin my speech, I am acutely conscious of the enormous cognitive stress most of you are undergoing after 4 dense and challenging papers. But the temptation to inflict my speech is too strong for me to resist, so I shall succumb to it happily. I promise you it will not be as bad, and I will finish on time. So, why are we talking about India? This question is quite natural because among post-colonial nations, India is a success story. Compared to several other nations, that gained independence after Second World War, India has come into its own. India has a robust legal system, is often touted as the world's largest democracy, and therefore one would not associate, at least post-colonial India, with questions of reparation and so on. The fact, however, is, though India was born in the throes of debilitating partition of this subcontinent, which resulted in the death of close to 1.5 million people and the homelessness of about 15 to 17 million people, post-colonial India has not always been very successful in dealing with communal solidarity issues. Of course, one problem that we in India face is that it is arguably the most diverse nation on the face of the earth. Not to mention also the fact that though India has just about 2% of the earth's landmass, we support 17% of the world's population. Canada has a per capita population density of 2. Okay, in India we have about 450. So if you put that many people in a small space, there is bound to be a lot of problems. United States is 3 times as big as India and has less than 1/3 of India's population. So it would be only fair to recognize that India has a lot of challenges. Even so, there were, in the last 70 years as an independent nation, several occasions where, due to callousness and unwillingness to form an inclusive society, although India has a democratic framework, there have been communal conflagrations, some of which matter a lot. In the literature, there has been a great deal of discussion about 3 major instances of communal violence. When I talk about communal violence, I generally refer to violence between different religious communities. That's how it is framed in the Indian political discourse. I wish to draw your attention to 3 of them that are quite troubling. The first one is in the northeastern part of India. I don't know if I can point this here. The northeastern part of India is here. You see the state of Assam. There are 7 states here. They're called the 7 Sisters. Assam is one such state. There was a massacre in 1983. 1,800 Bengali Muslims were slaughtered over a course of few hours on the 18th of February 1983. 1,800 is the official figure. The unofficial number, of course, is 3,000. This violence was directed mainly against Bengali Muslims who, over the years, have come to India from neighboring Bangladesh. Now, the Congress, Indian National Congress, which was in office in the state of Assam, it is true, provided patronage to these foreigners, illegal migrants, technically speaking, but they were basically economic migrants, and used them as a captive vote bank. There was a popular revolt against it, but the government of the day did not pay much heed to the trouble that was brewing. The net result was there was a carnage of extraordinary proportions. 1983 was when this unfortunate event happened. Subsequently, an election was held. The people who were in the vanguard of the movement for ousting these so-called foreigners, they were voted to office. And one of the first things they did was to take a decision in the cabinet to drop all criminal charges, including charges of murder, because many of them in the government were themselves perpetrators. So that was how this issue was resolved. 18 months later, if you see here in New Delhi, the capital, there was yet another mass murder. This time it was the Sikhs. The Sikhs comprise 2% of the Indian population. They are just 4% of New Delhi. New Delhi today, of course, is a bustling, polluted metropolis of close to 20 million people. in 1984, this city was witness to the killing of 2,733 Sikhs. This again is the official figure. Unofficially, the figure is close to 4,000. And the only crime that the Sikhs had committed was that one of them, bodyguard of then Prime Minister Mrs. Gandhi, shot her dead. You perhaps recall the assassination of Mrs. Indira Gandhi. And that happened because Mrs. Indira Gandhi took a very strong position on the insurgency in the state of Punjab right here. This state of Punjab had seen a great insurgency, and one challenge that the Indian government faced was that the insurgents, those that wanted a separate state of Khalistan, they would perpetrate acts of terror and seek refuge in gurudwaras. A gurudwara is a Sikh place of worship. The assumption was that the government would not send its paramilitary forces inside a place of worship. But Mrs. Gandhi, as the situation escalated, asked her security personnel to go inside these gurudwaras and flush out the terrorists. The final act of desecration, as the Sikhs saw it, came on the 4th of June 1984, when the Indian military stormed into the Golden Temple here in Amritsar. The Golden Temple is right there. It's the holiest shrine of the Sikh community, like the Vatican for Catholics, and it outraged the Sikhs a great deal, and one Sikh bodyguard of the then Prime Minister Indira Gandhi opened fire on her and killed her. Thereafter, there was an orchestrated pogrom literally unleashed against hapless, innocent civilian Sikhs who had nothing to do with it, and the carnage lasted several weeks. There was official complicity in it, and 4,000 plus people died. In the last 33 years, 11 judicial commissions have probed the factors that led to this crisis and have tried to apportion blame. 11 of them. And still, except for low-level party workers, it was the Congress cadres who had inflicted this violence. Except for low-level workers, the rest of them have not been brought to justice. In fact, many of them went on to become ministers at the federal level. Okay? Now, very recently, about a couple of months ago, the Supreme Court of India was forced to open 186 cases that were earlier closed by the federal government, because the court was convinced that there was enough material to proceed against the individuals concerned. Much later, in 2002, the state of Gujarat right here was under the helmsmanship of none other than Mr. Modi, the current Prime Minister of India. 2002 was when there was the BJP-led government in the state of Gujarat. The BJP, as many of you would know, are wedded to Hindu nationalism. They believe that Hindus must be, being the majority, must be given the place of pride, that everyone else must subordinate their religious identity to an overarching Hindu identity, and so on. There was, therefore, a great deal of tension with respect to a temple. Some of you might know this. I don't have the time to go into those details. But the net result was about 56 Hindus were burnt in a train accident. Now, the official story was that this was an act of terror perpetrated by Muslims. Unfortunately, that was not true, because a court of law, the trial court that went into this matter, acquitted 28 Muslims who were named, because there was no credible evidence produced by the prosecution. Even so, using that as a ruse, the state government under Mr. Modi unleashed a systematic series of violent attacks against Muslims in Gujarat, which resulted in the death of over 2,000 Muslims, and over 200,000 of them were rendered homeless. Since 2002, the judicial process has unfolded. It has gone through various iterations. The Supreme Court of India was once moved to remove two extremely sensitive cases out of the state of Gujarat in an unprecedented act. This court said, because of the profound viciousness that you find against Muslims here, the cases must be moved to Maharashtra, a neighboring state. Much recently, the court constituted its own special investigation team in order to investigate these matters. So the fact is there has been a great deal of fact fudging. Evidence has been tampered with and destroyed. The present Prime Minister himself was the target of an intense inquiry. He was interrogated, but crucial pieces of evidence were either ignored or suppressed, and the Supreme Court, unfortunately, was episodic in its enthusiasm for going against the culprits, and the net result is that the case is now closed. So all these violent acts, they share several common features. They were all directed against minorities. The goal was to teach them a lesson. They were the culmination of a long period of planned attacks. There were voters' lists that were taken, properties belonging to minorities, and their businesses were identified and they were targeted. There was a great deal of gore, violence, and brutality, like the like of which you saw in the Rwandan genocide in the mid-1990s. Thus, pregnant Muslim women were specially targeted. Their fetuses were ripped apart. Extraordinary levels of violence were inflicted. Top functionaries, constitutional functionaries, governor, president, and so on, they were not interested in intervening. The court also was not initially proactive, much less it was interested. It took on the matter, but it was too little too late. Prosecution in most instances, as you all know, has been very tardy, and there has been very little justice. So, in all these instances, the thing to remember is, since we're talking about reparations, what the Indian government has done is, and this government at the state level, they have provided what they call ex gratia payments. These are small amounts of money. Now, ex gratia payments are payments you make out of compassion, which means you do not recognize the rights of the victims. When the fact is, in international law, reparations have been recognized, and we all know that human rights advocates have come to a consensus that truth, justice, and reparations are duties that are owed by the states to people who have suffered grave human rights abuses. State obligations have been codified in the basic principles and guidelines on the right to remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law. This was codified by the United Nations General Assembly in 2005. There is nothing new in these basic principles. The state parties do not have any additional burdens. What the United Nations has done is taken relevant elements of international covenants like Universal Declaration of Human Rights, ICCPR, and so on, and said, look, if there is an erosion of human rights under your watch, then you have to make good that loss. You have to resort to reparations, and it can take the form of restitution, compensation, rehabilitation, satisfaction, guarantees of non-repetition, and so on and so forth. Now, reparation measures can take several forms. They can be individual, they can be collective, and things like that, but nothing of that sort has happened yet. In the Indian context, as I told you, the extent of ex gratia payment depends on how far the next election is. If the next election is close at hand, then the victims get slightly more, minus the speed money that they have to pay if they want to access what is their due. Corruption is endemic, as you all know. You also have to prove that you are the person that you claim to be, which is not easy in a context where you do not have the sort of infrastructure that we do here in terms of social security and things like that. So the net result is that In India, we do not have a law of reparation. The Indian state has not lived up to its international obligations. There are certain guidelines provided by the Ministry of Home Affairs. These are not solid guidelines in that they are on the books and are often honored more in breach than in observance. This is the classical point that Roscoe Pound made long ago about law in books and law in reality. You find that in India. So the question then becomes, if we have recognized the right to reparations in international law, how do you make a nation accept it, and how do you make it real for the victims? And as you saw, there are innumerable victims. I talked only about 3 major conflicts. There are several others that have occurred since India became independent in 1947. Now, you cannot obviously talk about reparations without taking into account the larger context. The infirmities of the justice system in India are too many to be ignored. One can talk about things like, say, as is often done, the number of judges per 100,000 people. In the US it's more, in India it's less, and so on. Tardiness in the system, overcrowding of the dockets, and so on. These are all supply side issues. They are very significant, but then there are more foundational challenges that need to be addressed if the grammar of reparations has to acquire any meaning in a post-colonial context. Thus, for instance, if you have sclerotic and effete institutions, if there is rampant maladministration, if there is growing inequality, as is the case in India currently, if the state pursues a predatory form of development, if civil society is weak, if the state is beset with a crisis of legitimacy, it will have a greater incentive to mobilize people along identitarian lines, because that is electorally very useful. In other words, the Indian state has great incentive in promoting such conflicts and protecting and literally providing patronage for those who perpetrate these things, because it results in the consolidation of the Hindu votes, and every political party wants to reap the benefits of such a vote bank. So when you have this incentive for electoral mobilization, when elites in India are apathetic, because India has not, in spite of being wedded to democracy, managed to create the architecture of social inclusion, a big challenge that we in India face. When there is popular acquiescence in state action, when rule of law is weak, you notice that, and of course, human development indices are very poor. I don't have the time to go into them. You are bound to find these aberrations. The overarching problem, however, is that there is a profound disjuncture between constitutional morality and atavistic social consciousness moored in primordial identities. In other words, India, as one great jurist once pointed out, has a first-rate constitution operating in a third-rate democracy. Now, when you have a context like this, as edifying as the Constitution might be, on the ground it is not going to deliver results. So the idiom of reparations will have to reckon with the context in which it unfolds, and the Indian context is not something that inspires much confidence. There is a great deal of sporadic development in the Indian situation. Thus, for example, if you have very progressive judges on the Supreme Court, yes, you see some movement. Then you have some conservatives adjudicating a matter, and then there is a setback. That is not the way to enshrine reparations. There's a great deal that in the Indian context offers by way of lessons for reparations, and I think it is important that we keep this experience in mind as we continue our discussions about reparations. Thank you, and I hope it was not too painful.
permission to have a few questions, 5 minutes of questions before we take a break. So, questions? Yes.
Yeah, I have a question and I have a comment about the second presentation. First of all, and I'm not trying to pat myself on the back, but I think it's important to add to your comments that there was an African descendant caucus that actually pushed the Caribbean delegation and the African delegation. I happen to be one of the co-chairs. And we saw in many instances the language that you were talking about as a small victory. And it was a small victory because we got so much resistance from the delegations, even those we thought were going to be supportive, that in fact getting that language that you talked about into the declaration was a small victory, to which we, even today, many people use it as a way to define the transatlantic slave trade and cite that. The question is, you didn't mention the program of action that actually listed a number of forms of reparations that the WCAR, the UN WCAR were recommending. Have you looked at those, and if so, how do you reconcile that with the language in 13, in 13?
So just to be clear, which recommendations are you referring to?
There was a program of action that was developed along with the declaration.
In the Durban Declaration.
In Durban. The program of action actually identified in it a list of forms of reparations. And so I wonder how you would reconcile that to the language. I think there's some tension there too. I agree with you in the overall thesis that there's tension. But how do you reconcile the recommendation, which was fairly strong,
Well,
the program of action, to the language in paragraph 13?
So admittedly, I haven't looked into these recommendations in depth, and I would clearly have to do that. Do you suggest any tensions between them?
I think so, but we can talk. I don't want to.
I would love to. Okay, yes, I would love to.
Because on
Yeah.
one hand, they recommended a list of things in the form reparations could take, but you're right, their language was somewhat equivocal.
Yeah, and I do want to acknowledge, though, that I didn't mean to imply that reparation claims in the Caribbean began with CARICOM. I do recognize that there's
I wasn't challenging that at all.
Okay, all right, well, okay, but still, we could talk about, okay, but let's talk, I would love to.
Yeah, I have two small questions. One goes to Anna as well. Did I read this right? Repatriation was one of the goals?
Yeah?
So actually meaning repatriation to Africa? Or?
Yeah?
Yeah, okay. And just to clarify, and the next question goes to you on it's not the question, it's more a comment. I mean, we have the issue with regard to the fact whether claims are hereditary claims, also with regard to the Holocaust claims. We're going to touch upon this briefly tomorrow. But even there, it's generally excluded. If we're looking at this as a potential model for the case of the Herero and the Nama, there are very few exceptions where it's not excluded that these claims are hereditary. Mm-hmm. Just something with regard to the living, the living years, it's a big issue. So.
You mean that in the Holocaust case it's the same problem? Yeah, okay, that makes sense. Yeah.
What was the question? We couldn't hear. Some of us back here couldn't hear the question or the comment.
Yeah. Well, what did you say? She didn't hear.
Oh, so the question was, the comment was about the fact that even in the case of the Holocaust, hereditary claims are very unlikely. That was the point, right? To be filed, yeah, or to win, yeah.
So we're actually going to take a brief break now before our keynote, but we'll have plenty more time to ask questions and continue this conversation. So please get some coffee to refill and then to meet back at 11:15. Thank you.
Oh, you.
So it's my honor to introduce our first keynoter of the conference. It's Professor Ana Lucia Arrojo. She's a professor in the Department of History at Howard University. As you'll see when you look at your abstracts, she's authored over 10 books on themes that include the public memory of slavery, Brazil Through French Eyes, Shadows of the Slave Past. I just finished reading her most recent book, Slavery and the Slave Trade, a Transnational and Comparative History, which was four squares on point with what this conference is about. So I'm really excited to hear her comments. Please give her a warm welcome.
Good morning, everyone. I hope you can hear. Thank you, first of all, Professor Robert Westley, and thank you also, Professor Roseanne Adderley, for inviting me to give this keynote address. I also thank Jacob Buttery, I don't know where he is, but for supporting the organization of this conference and also for making all my travel arrangements. Over the last 15 years, I have been working on how slavery is either memorialized or forgotten in former slave societies. This process is initially emerged in former slave ports of West Africa, such as Elmina, Cape Coast, and Ouida, as you can see here, and later became visible in Liverpool, Bordeaux, Nantes, New York City, and Salvador in Brazil. Here you have New York City, the African burial ground. The initiatives that made slavery more visible in the public space in these different cities and nations largely rely in the public on the commemoration activities through the construction then of monuments, memorials, and the organization, especially of festivals. In the various countries where these initiatives emerged, they were perceived as symbolic reparations. Putting then in place such initiatives was often then the object of long public debates opposing groups that were usually organized along racial lines. Some of these groups wanted to continue honoring pro-slavery individuals, whereas other groups of organized individuals wished to finally be able to pay homage to enslaved men and women who fought against slavery. Gradually then, especially after and since the 1990s, governments as well as prominent authorities and international institutions, along with groups that embraced then along with other groups, they started embracing the memorialization of slavery. And perceived then and promoted by by these authorities and entities, these initiatives were perceived then as symbolic reparations for the atrocities committed during the slavery. In other words, the construction of monuments, memorials, and museums became increasingly institutionalized. In the United States, the most recent example is the National Museum of African American History and Culture, with an entire floor dedicated to slavery. But I could also notice that despite these changes, the debates on material reparations remain very contentious, and material and financial reparations. Indeed, then after working on the memorialization of slavery for nearly 15 years, I could see that these ventures that we are talking about here neither healed the wounds of the slave past nor alleviated the legacies of slavery. Instead, we could say that they made more visible the scars of racial violence and racial inequalities, of which black populations, most of whom are descendants of slaves, are still the main victims in former slave societies. In the United States, Barack Obama was then the first black president elected then in 2008. And a few years after his election, Sojourner Truth and Frederick Douglass made their way to the visitor center of the U.S. Capitol. But as these slave fighters was set in stone in the U.S. Capitol, the blood of men and women, such as Sandra Bland, Eric Garner, Michael Brown, Tammy Rice, Freddie Gray, stained the streets of Baltimore, New York, Ferguson, Cleveland, and other U.S. cities. The landscape in other countries, such as Brazil, is not different. In Rio de Janeiro, for example, the largest slave port in the Americas, public works in preparation to the 2014 FIFA World Cup and the 2016 Summer Olympic Games uncovered the Valongo Wharf, a site where nearly 1 million enslaved Africans were disembarked between 1758 and 1831. Then following this major discovery, Rio de Janeiro's mayor, Eduardo Paes at the time, compared the site to the Roman ruins and promised the creation of a memorial exhibiting then the artifacts found during the excavation. But despite this political statement, the reality in the field was pretty different. And this is a very hard moment indeed. On the eve of the FIFA World Cup, as special units of the military police occupied Rio de Janeiro favelas, black men, women, and children were killed by the police. On March 17, 2014, a Sunday, 4 years ago, Cláudia Silva Ferreira, a black woman of 38 years old, who worked as a cleaner, left her home by 8 a.m. in the morning. And she went out to buy bread. She never came back. She was shot by the military police that was exchanging fire with drug dealers in her favela. The military police took her body and put it in the trunk of their vehicle. The body fell from the trunk and was dragged by the police vehicle for nearly half a mile. In Brazil, every year, 23,000 black young men between 15 and 29 years old are killed by the police. This makes 63 black young men a day, 1 black man every 23 minutes. Just in January 2008, the military police of Rio de Janeiro killed 154 people. Those who denounce this genocide are also destined to die. Yesterday morning, when I was preparing this lecture, I learned the news that Marielle Franco, Brazilian black woman, activist, and member of the Rio de Janeiro Council by Partido Socialismo e Liberdade, born at Favela da Maré, she accused, indeed, the police officers of using heavy-handed tactics. She was shot dead inside her car. Then today we are here to raise the dead, to hear the voices of those who demanded reparations for slavery, and also to hear the voices of those who still today fight against the legacies of slavery. In my work, in addition to notice then the disparities between the rise of these symbolic reparations, especially through these initiatives of memorializing slavery, and the disparity, then the contradiction between the emergence of these initiatives and the increasing killing of black men and women, I also observed that whereas symbolic reparations were increasingly embraced positively by several groups, every time that the discussion of material and financial reparations came back, this became a problem. In addition, despite the growing number of works on reparations by scholars in a variety of disciplines, with some exceptions, very few historians wrote about the history of demands of reparations for slavery. Then, here it's an exception because legal scholars, they had been engaged in this process since a long time. But for historians, it's not necessarily a topic that historians want to consider, because they consider, many of them, that this is a topic that is too much close to the present and that we should stay away from the debates of the present. Of course, that recent events also led historians to move a little bit, because especially when we are seeing all the debates on the Confederate monuments coming back, then historians now, they are really forced to consider the importance of the present. Then either in the United States, England, France, Brazil, Ghana, or Republic of Benin, we are living then in a moment that is extremely rich and also difficult, we can say, regarding the issue of the slave past. Unlike what we witnessed then in the 1970s, 1980s, 1990s, or even in the first decade of the new millennium, the growing interest in issues associated with the slave past is really undeniable. This interest then is visible not only in academic research, scholarly books, and conferences, but also in the organization of commemoration activities, exhibitions, as well as the creation of new museums, monuments, and memorials. This interest is also visible in the number of news associated with memorialization of slavery that appear online, especially here in the United States, almost on a daily basis. Then understanding the main elements of this wave, situating its beginnings, possible beginnings in time and space, as well as its ramifications, allow us then to see that although national contexts greatly shape present-day representations of slavery and the way its heritage is interpreted and promoted, there are also several elements in common that weave together indeed the processes of memorialization of slavery in former slave ports, such as Charleston, Liverpool, Rio de Janeiro, Ouida, New York City. However, the present times, our times, they offer unique challenges. These challenges, we are going to try to discuss them. Scholarly research recently, over the last 30 years especially, uncovered the history of regions whose ties with the slave trade and slavery until recently had remained largely unknown. We can give several examples, such as Denmark and its Caribbean colonies, Barcelona and its Spanish colonies of the Americas, like present-day Argentina and Mexico. I'm not even talking about Brazil and the United States here. Then the tangling the battles between history and memory, which I define as two modes of discourse that are related to the past, though they are different. The tangling these debates become then even more important in these days. In these days when public authorities in this country and other countries question the existence of historical facts, undermining then the quest for truth. Yet the ways that history and memory engage with the slave past can greatly differ. This is why the debate on these issues has never been so necessary. But in these times that public memory of slavery is increasingly institutionalized, demands of reparations, financial and material, are again resurfacing. And here I'm talking about demands of reparations for slavery, Atlantic slavery. In my recent book that Robert mentioned, I argue that not only these demands of financial and material reparations are very alive, but they have a long history. And this is the problem when we say, we see some of these arguments that were brought in the previous panel, this argument that this took place a long time ago, or the victims are no longer alive to speak. Indeed, when we examine this history, when the victims were well alive, they were already demanding reparations, and their demands were not heard. Since the 18th century, indeed, enslaved men, women, and freed individuals started then conceptualizing the idea of reparations in a variety of documents, written documents, that people, they like written documents, correspondence, pamphlets, public speeches, slave narratives, judicial claims, all these written in a variety of languages. These records, they exist, they are out there. In different periods, despite the legality of slavery, slaves and former slaves showed how conscious they were of having been victims of an injustice. They were aware they provided unpaid labor to their owners, contributing to their wealth. They also fought back and demanded reparations when they were unlawfully held in captivity. Then, drawing from this consciousness, the trailblazers who addressed the first demands to governments and former masters for reparations, they clearly stated that not only they must be freed, but that they were owed financial and material restitutions. Now, historically, the term reparation has been employed to convey the idea of making amendments for past wrongs. You can say that this is one definition of reparations. During the 20th century, the idea of reparation appeared in international law, and you know this better than me, and in the human rights field to describe then the redress of physical, material, or moral damage inflicted then on one individual, a group of individuals, or even a nation. In customary international law, reparation was then associated with measures to indemnify nations for wartime damages. But such amendments, of course, always contain two dimensions. The first is moral or symbolic, and usually consists of apologies and actions to help those who were victims of wrongdoing. The second one carries a financial and a material scope. In other words, the victim of past wrongs also obtains money or other possessions, such as land, as payment for the misconduct inflicted. Ultimately, then, reparations can carry only a symbolic aspect through recognition of the harm inflicted, apologies, and symbolic measures that can include, for example, the construction of a monument or a memorial, the creation of plaques, the renaming of buildings, all this to honor the victims of wrongdoing. But reparations can also carry a material and a financial dimension. In previous work, I looked a lot at the symbolic dimension. But here, let's pay attention to the financial and material dimension of reparations. During the era, then, of the gradual abolition, a small number of slaves, former slaves, demanded either the government or their old masters to provide them with pensions or some kind of financial reparations. In the United States, for example, we have the iconic case of Belinda Sutton, an African-born woman owned by the wealthy Isaac Royal Jr. of Massachusetts. Royal Jr. left Massachusetts during the American Revolutionary War, and in his will, he instructed his grandson to pay Belinda 30 pounds for 3 years. But after his death, then, in 1781, one assumes that Belinda was paid the sum indicated in the will. But then 3 years later, the payments stopped. Belinda then petitioned the Massachusetts legislature at the time, requesting a pension as reparations for the unpaid work she provided to the royals. Even if only partially successful, Sutton, or Belinda, if you want, she was the first non-successful case of individual reparations awarded then to a former slave. I am sure that many others will come with new research and we will prove that I am wrong, that she was not the first and that there were several others who did the same. Then, although numerically small, these first demands by individuals that emerged when slavery was far from being abolished give us a broader perspective to understand then the discourses of these first social actors who engaged in formulating demands of reparations for slavery and the Atlantic slave trade. In other words, the first calls show that demands for reparations have a long history in the Americas. And not only in the Americas, we know now also that those working with the transatlantic slave trade in the Indian Ocean as well, they can find similar cases. But both in the North Atlantic or in the South Atlantic systems, slavery and the slave trade generated then significant financial profits that greatly benefit merchants, planters, and other elite groups in Europe and the Americas. The Atlantic slave trade initially brought economic gains and especially political power to a handful of West African and West Central African rulers, who at the time, by waging wars, obtained captives to be sold in the Atlantic slave trade in exchange for luxury goods and weapons. But this cycle of violence and war eventually opened the path for a sustained European presence in these regions of Africa that by the end of the 19th century then facilitated the establishment of colonial rule in the continent. Then the Atlantic slave trade had enduring nefarious impacts on the great majority of the populations of these African regions, which can hardly be measured to statistical data. In both Africa and the Americas, the Atlantic slave trade left then a trail of blood, death, disease, sexual violence, and trauma, experiences that, although hard to quantify, these were experiences that were transmitted to later generations. But still today, then, the legacies of these atrocities remain alive in the collective memory of the various populations who were victims of these extreme and complex forms of violence. And anybody here doing field work, interviewing people in these areas, either in the United States or the Caribbean or Brazil or West Africa or West Central Africa, they can find the traces of this long lasting trauma. But because slavery and the Atlantic slave trade were the engines of an economic system of production for many decades, indeed, historians prefer to focus on its demographic and legal dimensions. These scholars, and here I think that most of them, they are historians, they failed in providing responses that adequately address the point of view of the victims of this great human tragedy. But as the history of slavery is still being written, and as the groups who identify themselves as descendants of the slaves remain excluded from historical narratives, what I propose in the kind of work that I do is an approach that combines history and memory to take into account then any human system that interconnected then 3 continents for more than 300 years, and that is still today fuels debates on the need of reparations. Now, if we move towards this history of reparations, between 1804 and 1888, when slavery was abolished in Brazil, all societies in the Americas, they ended up abolishing slavery. But the end of slavery, we know, was a lengthy and gradual process, even in regions traditionally referred by historians as freedom havens, such as the north of the United States and Mexico, for example, where slavery was abolished earlier than in many regions of the Americas. Even in those places, the end of slavery can hardly be defined as a straightforward process. From Cuba to Brazil, public debates among abolitionists and pro-slavery groups reveal many common features. Slave-holding elites emphasized that slavery and the slave trade were legal, and that property rights should be respected above all rights. But abolitionists, they also utilized legal arguments to denounce, for example, that thousands of Africans were imported to the Americas illegally, and this was unlawful. Then, because of that, it was unlawful to keep in bondage these Africans and their descendants. Robert mentioned in his opening remarks today the case of Clotilda. But this was one case here in the United States. In the case of Brazil, we are talking about several hundreds of thousands of individuals who were illegally imported. And you are going to arrive there. But let's come back to the United States. The internal slave trade, after the abolition of the trade from Africa in 1807 by Britain and then 1808 in the United States. The internal slave trade continued alive in countries such as the United States, and many free individuals, indeed, were unlawfully enslaved, even beyond national borders. In the United States, two cases can be highlighted. There are certainly several more. In 1841, Solomon Northup, a free African-American, was kidnapped and enslaved, brought to the South, Louisiana. His case became famous because of the narrative 12 Years a Slave and the film that by Steve McQueen that was released in 2013. After Northup was eventually freed, with the support of a number of abolitionists, several petitions were submitted requesting the U.S. Congress to pay him reparations for his illegal enslavement. Despite this several calls, and you see here one of these petitions, the U.S. Congress did not hear these petitions requesting financial reparations to Northup. In a letter then addressed to William Lloyd Garrison, this is a letter of March 1855, and published in the newspaper The Liberator, abolitionist Henry Clark Wright narrated Northup's case. He concluded in his letter, stating that to Northup, the Union was a confederacy of kidnappers, and asked, quote, "Where is the church or political party that will refuse to open the way to give this victim of slavery a hearing and repay him for the suffering this union has inflicted on him? But there are 4 million of kidnapped men, women, and children still under the American lash. Who will help to redeem them and pay for their sufferings," unquote. Northup's case then encouraged U.S. abolitionists to defend, although timidly, financial reparations to former slaves in several occasions before the beginning of the Civil War. But Northup was not the only free African-American unlawfully enslaved. In 1848, the case of John Little also gained public attention. Little was born free in Philadelphia, approximately in 1817. He worked on board of the ship Jupiter that sailed the Atlantic Ocean. After a shipwreck, he ended up in Sierra Leone in West Africa. By 1837, slave merchants had sold him and transported him to Cuba, where for 11 years he was maintained under slavery in a plantation. In 1848, Little denounced his unlawful enslavement to journalist John O'Sullivan. And Sullivan was then visiting the island at the time. Consequently, the Council of the United States in Havana, Robert Campbell, supported Little's demand for freedom. The outcome of this incident is among the few cases of reparations to an individual illegally enslaved. Then, in addition to be freed, the Cuban government, it's the Cuban government that paid Little reparations for the 11 years he was maintained in slavery. This didn't happen here in this country when you are talking about Northup. Liberated, and he returned to the United States and joined the abolitionist cause in New York City. Unfortunately, many other men and women and children then unlawfully enslaved had not the same fate. The debates on reparations during the period of emancipation shed light on how a variety then of social actors conceived property rights and how they envisioned the future of the freed populations in the public spheres. Now, this is the case of Brazil during the period of the abolitionist movement that in Brazil emerged very late in the 1870s. And in the case of Brazil, we have another problematic layer that I added, that I mentioned earlier. The slave trade from Africa was banned in Brazil by the law in 1831, but was not fully enforced. As a result, just between 1831 and 1850, nearly 1 million enslaved Africans entered Brazilian ports. This number alone is almost 3 times the number of enslaved Africans that were brought to the United States during all the period of the Atlantic slave trade. Only during the period of the illegal slave trade to Brazil. As a result, most of these men, women, and children and their descendants, they were kept illegally enslaved in Brazil until 1888, when slavery was finally abolished. There were a number of them who were able to make claims at the time and get a special status, but the great majority of them continue enslaved, their children as well. Brazilian abolitionists were aware of these crimes. During the 1870s and the 1880s, they were among the few activists defending reparations to former slaves. And here I'm talking about especially the black abolitionists. In 1883, black abolitionists such as Luis Gama, that you see here in this photograph, he calculated the amount due in salaries to slaves in Brazil. And I quote him, "Do they have by any chance an idea of the sum they owe in salary to the generations that succeeded in captivity for 3 centuries? Let's take the number of 1,500,000 slaves, indeed a number that is 3 times smaller than the number of enslaved Africans imported to Brazil. But at that time, these numbers were not very clear. Then he was taking this number, 1.5 million. With a salary of 1,000 reais, the equivalent of today, $50, during 300 years, or 90,000 business days, and we will arrive to the prodigious number of 135 billion reais. In today's currency, you could talk about $49,850,000,000, unquote. And of course, that all these calculations, every time there is a demand, but abolitionists, they were calculating these amounts, even with smaller numbers of, smaller estimates of the imports of enslaved Africans since the 19th century. Now, since the emergence then of the abolitionist movement, although some anti-slavery activists occasionally invoked the need for reparations to former slaves and their descendants, for example, through land redistribution, wages, and education, that is more in the field of symbolic reparations, what really prevailed in these public debates among abolitionists were the demands for financial compensation for former slave owners. This is what prevailed. Then how to pay reparations to former slaves was never hegemonic in these debates. Most of these debates, even among the abolitionists, the center was how to compensate former slave owners. The gradual end of slavery in the Americas during the long 19th century was really planned to protect the interests of slaveholders and planters. Even Haiti, the only country to, at the same time, become an independent black nation and to abolish slavery, Haiti had to compensate former French slave owners. In 1825, then this is 2 decades after 1804, Haiti agreed to pay to France 150 million francs in 5 installments in order to allow France to compensate the former colonists. The calculation of this amount was based then on the annual revenues obtained by Saint-Domingue's planters at the time from sugar, coffee, indigo, and other commodities then during the period, during the colonial period. And also included then the value of the urban properties they lost in 1789. Although not included in the initial calculations, historians agree that slavery property was considered in the evaluation and the distribution of the indemnity to the French planters and slaveholders. To different degrees, slave owners received at least some kind of monetary compensation. Then in the British Caribbean, it's sure. In Washington, D.C., you can see here, former slave owners, they received compensation. Dutch Caribbean, this is, I cannot read Dutch, I'm not making this claim, but this, it was a picture that I took when I visited the Black Archive in Amsterdam last December. And again, then the Dutch slave owners also received. The French Caribbean, the former slave owners received compensation. Miriam will talk about that, I believe. And in Brazil, there was no compensation with the abolition of 1888, but during the gradual abolition, slave owners, they were always getting some kind of compensation when, for example, we had the free womb law, the law of the sexagenarians, and so on. Then, after emancipation, we can say that even after then slavery ended, either in the British Caribbean or in Cuba, the creation then of apprenticeship systems indirectly rewarded many former masters who kept then freed people under their control by paying them symbolic wages. Then the masters, they are still getting from freed populations even after slavery was abolished. In the United States, the period that followed emancipation brought hopes of land redistribution to freed people. We know that these projects failed. When Reconstruction ended, the prospects then of obtaining land and full citizenship were replaced then with disenfranchisement and increasing racial hatred. It was at that point that former slaves here in this country collectively requested financial reparations. During the 1890s, thousands of former slaves petitioned the government of the United States to pass bills providing them with pensions for the time they were enslaved. The leaders of this movement, which historian Mary Frances Berry examined in detail, conceived the payment of pensions as financial redress for the many years of uncompensated labor that the slaves provided to their masters. The greatest leader of this movement was a black woman, a washerwoman and former slave. Her name is Kelly House. On September 29, 1899, she wrote a letter from here, from New Orleans, to the general of the post office department. And I quote her. Here is the part of the letter. She says, "We are organizing ourselves together as a race of people who feels that they have been wronged. An object of this movement is to petition to Congress to pass Senate Bill 4718. We do petition for the said bill or some other similar to it become a law to pay us as an indemnity for the work we and our foreparents was robbed on from the Declaration of Independence down to emancipation of our 1.5 million slaves, turned loose ignorance, barefooted and naked, without a dollar in their pockets, without a shelter to go under out of the falling rain, but was forced to look the man in the face for something to eat, who once had the power to whip them to death, but now have the power to starve them to death. We, the ex-slave, feel that if the government had a right to free us, she had a right to make some provisions for us, as she did make it soon after our emancipation. She ought to make it now. I ensure that the officers of this organization have not promised its members anything, or have we ensured them that they will get anything. We have perfect right as ex-slaves to assemble ourselves together and organize ourselves and elect men and women to organize our race together to petition the government for a compensation to alleviate our old decrepit men and women who are bent up with rheumatism from the exposure they undergone in the dark days of slavery, unquote. The bill demanding pensions to ex-slaves generated great mobilization and debates, but they never passed. Moreover, the authorities persecuted the leaders of the movement, who were sent to prison, and ultimately they never achieved their goal. Kelly House, she spent 1 year in prison. She died 90 years ago. She is buried in an unmarked grave in Nashville, in a Nashville cemetery. Meanwhile, we can say that during the 19th and early 20th centuries, other former slave societies such as Brazil, Cuba, and Colombia did not witness any collective movements demanding reparations for slavery. Although in these countries, former slaves were deprived of material resources, they privileged, indeed, the struggle for citizenship, where in societies where the ideologies then of racial democracy and mestizaje predominated and hindered this kind of collective consciousness that you are going to see here in the United States. But in the period that followed the end of the Second World War, this context started changing, especially after the Jewish survivors of the Holocaust obtained restitutions. In this new landscape in which governments paid compensation to victimized groups, the renewed call for reparations, then either material, financial, or symbolic, then for more than 3 centuries of slavery, eventually started gaining more public attention. In 1959, what happened in Cuba, for example, is a different situation. Cuba staged a revolution which was followed by an extensive agrarian reform and ultimately redistributed land to black Cubans. We can question more how this process was, but black Cubans, they got land to land redistribution at that point. Meanwhile, in the United States, the civil rights movement, we know, hardly ever defended reparations for slavery that were not a central element in its overall agenda. But it's still during the Cold War in the United States, even though reparations activism was constantly associated with the label of communism, several groups advocating then reparations surfaced. And here I'm talking about in the 1960s. During the Black Power era, the movement gained new blood, the movement for reparations, with the rise then of the Reparations Committee for the Descendants of American Slaves, led again by another woman, Queen Mother Audley Moore. And here we have her in a picture of 1995. This is in the Men March in Washington, D.C., along with Rosa Parks, that you can see here. Then she fought for reparations until her death. The Republic of New Africa, the Black Manifesto, also authored and disseminated by James Forman. And here I want to emphasize the importance of black women. We have Foreman, but we had several cases here of black women who led these movements. Black women are still leading these movements in, for example, the Quilombola movement in Brazil. They have an important presence, and they are these leaders. And I think that we don't don't often call attention to how black women, they were important in this movement. But as the end of the Cold War, and I know that the time is going to end soon, but I am almost there. As the end of the Cold War then approached, the government of the United States, we know, paid restitutions to Japanese Americans who were unlawfully interned in camps during the Second World War. Then with this precedent, the end of the 1980s and the 1990s provided a new ground for a renewed wave of demands of reparations for slavery. Brazil, Colombia, and Ecuador, for example, enacted new constitutions recognizing the right of land ownership to for their black communities. Then, also in Brazil, in the 1990s, you are going to see a number of groups emerging demanding financial reparations, including student groups that you can see here, a group called then Movimento pelas Reparações Já, and this then Movement for Reparations Now. And they organized a series of petitions, including one petition that indeed included, and I don't have her picture here apparently, but one petition that included the signature by a former enslaved woman, a woman that was born in 1871, before the passing of the Free Womb Law. Then in the United States, you are going to see during the same period new organizations combining then activism and litigation, requesting reparations. You see then here the iconic statement then, slogan, 40 acres and a mule. The echoes of this movement are also heard in Africa. Then we already talked about Durban here. We also talked about the CARICOM demands, and I think that this is a turning point in the more recent period, when CARICOM issued these demands of reparations in the 10-point plan in 2014. This renewed the debate in the United States, in Brazil, in Europe, and this is where we are now. Then it is the CARICOM wave that we are living now here in the United States as well. We know that then, however, that despite these movements and the recurring debates on whether governments and other organizations should award reparations for slavery to the populations of African descent, in which forms these reparations should take, to this day, no former slave society in the Americas has paid restitutions. We know that no European countries paid financial reparations to their former colonies in the Americas. All of these colonies relied on slavery, at least to some extent. And there was the case of Haiti that was mentioned here in the previous panel. Then François Hollande, he wants a good relation with Haiti, but up to now is no question of, it's no longer François Hollande, but in any case, France is not making any provision to return the money that they got from Haiti to recognize their independence. And the point that I want to make to go to the conclusion is really that the ways that the demand of reparations for slavery and the Atlantic slave trade have been historically addressed are deeply connected to the peculiarities of the slave systems that prevail in the societies where they emerge. These requests are also linked to the particular processes that culminated with the abolition of slavery in the several countries, and also associated with the directions taken by the societies during the post-abolition period. Likewise, the demands for redress are related to how former slaves and their descendants achieved, or at least attempted to achieve, citizenship in former slave societies. Call for reparations, of course, are also associated with the ways Black activists responded to the legal systems that imposed racial segregation and to the ruling ideologies that promoted racism and reinforced white supremacy. In other words, reparations can be a framework, a window through which we can understand the slavery, emancipation, and the social and economic and racial inequalities that emerged during the post-emancipation period and that persist today. It's worth emphasizing that the study of slavery and its legacies, and I think that is important to bring that in an academic conference because some of you are more engaged with other organizations that call for reparations. But it's important in an academic conference that to emphasize that the study of slavery and its legacies remains a hard ground full of quicksand spots and imbricated in power structures. To this end, I think that it's important to once again recall that we should question who collects historical data, who controls historical records, who regulates the publication of conclusions resulting from academic research on slavery, and how this research has been made available or not to larger audiences. Works written by historians in particular have played and still play an important role either to highlight or to minimize the importance of the wealth generated by the Atlantic slave trade and slavery, by necessarily impacting then the discourses of activists who contributed to formulate the demands of reparations. Still, historical research can also bring to light how descendants of the slaves remained socially, economically, and politically excluded. Then the analysis of primary sources that we historians do also can reveal how some states, companies, and universities, for example, as well as other individuals and their descendants, largely benefited from the slave trade and slave labor. Evidently, such body of evidence can eventually support the work of organizations to establish their demands of reparations. Then when studying reparations for slavery from a global perspective, we are led to recognize that despite these movements and debates on whether governments and other organizations should award reparations for slavery to the populations of African descent and which forms this reparations should take, up to now, this is a history that is still to be written. And there are a number of questions then that remain unsolved, and these we'll be discussing here because I am not proposing here to answer these questions. The questions are who should get reparations, how much, who should call, who should pay reparations. Even the CARICON 10-point program, and Professor Shepard is here, perhaps she'll disagree with me, but even the CARICON 10-point program has a big focus on symbolic reparations. Then, of course, we don't have any consensus here. We are talking about global perspectives, but this does not mean a solution that can cover every single region. Then certainly we can have several answers. Policymakers, for example, political scientists, economists, and legal scholars are certainly better equipped than historians to answer these questions. Still, these answers must take into account the historical particularities of societies demanding reparations. And this is why I engaged myself in historicizing reparations. It's important to understand that the social actors demanding reparations changed over time. Initially, they were slaves, free individuals, illegally enslaved, and later they were freed men and freed women. Abolitionists also made rhetorical demands of reparations to governments. Former slaves and slaves individually or in small groups demanded reparations to their former masters. Later on, we are going to have, when freed people were dead, men and women claiming the identity of descendants of the slaves, they continue demanding reparations to former masters, to governments, to churches, to companies who insured and or profited from the slavery. Descendants of the slaves are demanding symbolic and financial reparations to the institutions who sold their ancestors to pay their debts. Today, this is the case of Georgetown. Then today, demands of reparations go far beyond requests of amounts of cash to particular individuals and groups. Instead, we have a variety of groups and even nations that collectively or individually demand financial and material reparations to other groups, companies, and governments. As never before, then we have now groups in the 3 continents involved in the Atlantic slave trade, then creating ties in order to establish possible common grounds to fight for reparations. This wealth of modalities of reparations is promising, but is also, of course, a danger. The danger of making the term reparations a sort of commonplace and an empty idea, which leads us to consider any minor gesture as reparations. And I invite us to think about that. Finally, last sentences. I would like to say that the history of demands of reparations is still being written. It's being written now by us academics gathered in this conference. And gatherings such as this one, exploring the global redress, are important because they call us to understand the history of slavery and emancipation as a history that is not confined to national borders. And these exchanges also propel us to understand the history of reparations beyond these national frontiers. And by doing so, we hope to better position ourselves, to understand this long struggle, and also perhaps to better fight for social justice and against racism, racial inequalities, and white supremacy. Elements that still haunt our societies. Thank you so much. Let me know if you have questions.
Jake has it.
Are we going to do questions?
Yeah.
Very much enjoyed your presentation, very comprehensive. I actually teach at Howard Law School, so I'm going to try to find you, back there. One thing you might want to look at, with respect to the Republic of New Africa, that particular, kind of intervention, you can kind of connect that back to the black Muslims who made a similar demand and then went ahead and bought land themselves. But the black Muslim demand can then be traced back to Marcus Garvey, obviously. And what's an interesting, kind of little historical, kind of wrinkle is that the Communist Party of the United States, under I think it was the Third International, Stalin was in power at the time. Stalin was putting out a whole notion of nations within a nation. And the Communist Party of the United States saw the demand for 5 states in the South as a way to organize among black, former sharecroppers, black tenant farmers in the South in the 1920s and 1930s. This is a way that they saw how much power, how much energy Garvey was eliciting from the black population. I thought, well, we won't be talking about repatriation back to Africa. We can use this to destabilize the United States. So that was their thing. They were in Detroit when this guy, Fard, F-A-R-D, William, I think it's Fard, who was the person who Elijah Muhammad identified as the person who he learned from. This is all going around in the 30s. So you can probably make it an ironic, I think, but complete connection between the Communist Party, Third International of the 1920s, Garvey, and the RNA, and the stuff that happened in the 60s.
Yes, just to respond, this is in chapter 3 of my book. then the black belt thesis, Haywood, exactly, and Audley Moore, Queen Audley Moore, she was a member of the Communist Party. Then I bring in that chapter, for example, Garvey, that really he made rhetorical demands of reparations in many ways. Also Paul Robeson, who was associated, connected to the Communist Party. Then I explored that connection. But of course, when trying to write this history, it's like to write about resistance against slavery. Where there was slavery, there was resistance, and where there was slavery, there were demands for reparations. And I think that this work, what led me to do that, it is really this, to contest the idea that these demands are recent. Then these demands are not recent, these demands are old, they have been there all the time. And even among academics, we are not aware of that. Even among African Americans who were raised in this country, it looks repetitive. For example, when I wrote, I had one chapter that I had to talk about the ex-slave pension movement. Mary Frances Berry, she wrote an entire book on that. And I am surprised to know that people, they don't know that story. Then it's never too much to revisit these stories. Of course, that in the course of the research, we can find things that are new. But there are things that are old that deserve being retold, and also that they deserve to be connected, because I think that this long perspective, I think it's important, and also to see the fact that many elements that perhaps we saw here in the United States, we could find perhaps in other places, even if the similarities are not necessarily identical. We have elements of dialogue, and this is why it's important then to continue this dialogue with people who are working on these issues in several other countries.
We do have another question back here.
Boa tarde.
Cedric Miles.
How are you?
My Brazilian friend.
Do you think that there's any evidence of like a transnational dialogue between African Americans and Afro-Brazilians in a contemporary way that is evidence for sort of a transnational scope, at least between the two groups, about reparations? You know, because there's some similar justice issues that I think will be, are being revealed and will continue to be revealed, over the next years. Do you think that there's evidence of a dialogue about reparations, the idea of reparations between those groups?
There is a lot of evidence of dialogues of all kinds. Then we were talking about black women. Or then there is a growing dialogue, I think, that with the rise of the internet. But regarding the issue of financial reparations in Brazil, it was a little bit in decline, because with the rise of civil rights in Brazil over the last governments of the Workers' Party, I think that most of the focus was being put on symbolic reparations. But now that civil rights in Brazil are really on the downside, these demands of financial reparations will perhaps emerge louder than they were. For example, the issue of the Quilombo communities, when we had the World Cup and after, it was the Olympic Games, there was an article in the Huffington Post saying that this was the largest program of reparations in the world, a big claim. At the time when I was writing this book, I was not feeling comfortable in saying that it was not the case. Because indeed many of these communities, they had their lands recognized, but they never got the title. There are few of them still who got the titles. And I was feeling uncomfortable to state that. But then 2 years later, this is what happened with Brazil. And we know that these communities who didn't get those titles in the period of the rise of the civil rights, now perhaps you never get those titles. In terms of the dialogues, there is in Brazil now, and this is not something for me, but this is for the legal scholars. But I know that I have all the context to give to you. In Brazil, there is now a commission the Truth Commission for Slavery. And this commission in Brazil is not led, of course, by historians, and indeed is led by black attorneys. Then the Bar Association in Brazil created a commission that is similar to what is proposed by the HR 40 bill that is introduced every year by Conyers. But in Brazil, the Bar Association created this commission. What they are doing, perhaps, without knowing perhaps much where to go, is to revisit a little bit the history of slavery in Brazil. They are based in different states. I had contacts with people in Rio de Janeiro and Rio Grande do Sul, the state that I come from. But the report of this commission in Rio de Janeiro, they talked about reparations in the last one. And this is a report that is more than 1 year ago. And they are thirsty to have these contacts with U.S. activists and U.S. legal scholars doing work on that. And I think that it's time for you to move. But of course, that there are things that are hard. For example, I have contacts of people that they want to come to Howard, they want to come to Washington, D.C., and there are things that I just don't have the means to bring them, or to establish this kind of dialogue. I am not a legal scholar, but you have those means, and I hope that perhaps you can do something. Then these dialogues are there, and there is a lot to be done.
Thank you very much. Very, very thorough and informative presentation. 2 points. The link between the law and specifically in the punishment of Callie House used to actually chill organizing around reparations. The charge that she was imprisoned for was actually fraud, because they said there was no way she could actually reach the goals that she was organizing people to participate in. Do you have other evidence of how the law was used historically to quiet the reparations movement, to chill that movement?
Well, let's start with Callie House. Then she was sent to prison at a time. Then it was the post office, through the post office, that they were able to send her to prison, because they were requesting an amount of money to be member of the association. Then indeed, they considered that as a fraud. Then it's clear that she was targeted. Other more prominent and perhaps members of the association that were men or had a higher position, they didn't have the same end as she had. The only thing I can say is that all the time, that these movements, I had people who told me that this was not even a movement when I presented a chapter on this before having the book done. But these movements were so not dangerous that the FBI, the CIA, and the government authorities were always persecuting them. Then these were radical movements for their time. And if you read what she wrote at the time, a woman that was barely illiterate, we see how conscious they were and how that woman is speaking to an audience, how she could raise, then we are talking about a movement with thousands, that the estimates even to 600,000 people who joined the movement. Another element, do not forget, Marcus Garvey also, fraud, and all of them, all the leaders of these movements, they were targeted. Paul Robeson had his passport confiscated, and so on. All these people, the Republic of New Africa, James Foreman, that have thick FBI files about them. Then there is these movements. They were considered as radical movements at their time. At their time, and I think that the authorities they were pretty aware of that. Today, of course, we have a much more varied number of groups advocating for reparations, but the law was used to incriminate this group since the beginning, and the law was also used to pay compensation to former slaves, and the law was not respected when it was the case in Brazil, when about 1 million enslaved Africans entered the country illegally. Then it's tricky. Of course, as a historian, I don't need to worry much about the law, about the legal arguments. I even had, for example, a few days ago, I was explaining to a Brazilian political scientist that that the former slave owners, they got compensation in all places. And this scholar, she looked at me and said, but do you think that they would abolish slavery if there was no compensation? Then this is a question that had never passed my mind to ask that kind of question. Then I think that these are debates that we should continue on. You just cut me if I'm speaking too much.
You're not speaking too much. We may be asking too much of you, but I have really enjoyed your presentation. And the last point that you just made, I thought, having read the book, was one of the most transformative aspects of the research that you've done, in showing that in most of the places where slavery was abolished, reparations was in fact paid to the slave owners and not to the slaves. And often the reaction that I get from people is a sort of stunned reaction when they hear that fact. In the U.S. context, of course, there's one big exception to that. That's the passage of the 13th Amendment, but even prior to the 13th Amendment, the U.S. government was paying slave owners in order to give up their slaves. So, so I think this is part of the reason why I think the sort of historical turn in this area is so important, because when people hear those kind of facts, it kind of transforms the debate. One thing I wanted to return to, however, is your comment about the way in which the term reparations itself may actually lose part of its meaning if we start talking about small things as reparations. I understand the danger of that, but there actually is, I think, some scholarly discussion at this point about so-called micro reparations. And I think part of the problem with the reparations discourse is that we tend to think of it in very large terms. There's some kind of grand bargain that's going to cover everyone and end all injustice. And so I'm actually somewhat sympathetic to the idea of micro reparations as a way to sort of keep this idea of reparations going while a bigger settlement, so to speak, is worked out. And I just wanted to hear what your thoughts are about that process.
Thank you. I am glad that you brought that again, because when you went, I was rushing to finish, and I don't want that to be an idea that is not developed. When I was talking about that, I was making, I had two ideas in mind. For example, things that were done in Brazil over the last decade. And in Brazil, there is a lot that is being used, this term reparatory. Everything is reparatory. Like we are teaching Black history in Brazilian schools that should have been taught for the last 100 years, and this is reparation. We put a pebble at Harvard University with a plaque to the enslaved workers there, and this is reparation. Then at some point, and this is why I became also tired and why I wrote this book, because I was dealing with the pebbles, with the plaques and the monuments, and at some point, of course, this is a gesture, is that first step, the apology, the gesture, but we cannot start calling everything reparations. For example, in some, I will not cite places this time, but in all these universities now, they are studying their involvement with slavery. They are calling this reparations. This is their duty as historians to study this history. They are not paying anything to anybody by doing that. They are just doing what is their job. And if they didn't their job up to now, shame on them. But it's just that it's something that is their obligation to do that, and they are not, nobody is grateful for that. Now historians at Georgetown, at Harvard, Princeton, UPenn, they are finally studying the links of reparations, and you should say, thank you so much for doing that for us. Then this is in that sense, but I will not go further. Professor Shepard.
We'll take one more, and then we'll break for lunch.
Thank you very much for your lecture. I so enjoyed it, and thank you for your book. I just wanted to add to the discussion on the payment to enslavers that the news out of Her Majesty's Treasury in the UK that broke on the 9th of February, well, it broke before, because the New York Times actually had a piece on it, or the Washington Post, sorry. It strengthens the argument that we're not only talking about the past, because the 20 million pounds, and if you add the scamming called apprenticeship, it could be 47 million pounds in the case of the CARICOM region, was not really paid off until February 2015. This is what we have just learned, that the money was borrowed, and then, which was about 40% of the treasury at the time, but it was recapitalized, and interest payments accumulated, and people bought government bonds and gilts in the UK. And so people have profited from that money. And the most scandalous part, I think, is that the descendants of enslaved Africans who live in the UK, who are taxpayers, actually help to pay that money. So it's an ever-present issue, and I think it is strengthening the movement right now as far as the Caribbean is concerned. And the second thing is that you talk about reparation becoming commonplace, quote unquote, no, not your words, mine. And in the search for evidence that enslaved Africans were making this demand, people are extrapolating from the resistance movements that this could be framed within that discourse. And I am curious to know how you relate to that, because you have firm evidence and you have listed some cases. And Randall Robinson has the famous case of Jordan, of Big Spring, Tennessee. Are we to frame the reparation discourse within the discourse of the resistance movements and all the cases of resistance, or we should really do our work and dig deeper?
It's hard to answer, but my impression is that we should do our work and dig deeper. Of course, that what people are doing after slavery ended. Of course, there are elements here that is this big framework of resistance, but they are demanding things that are concrete, and I think that we should be looking at those things. Of course, that even in the book, and if we look about rhetorical demands of reparations, we can find even in the slave narratives. But even if rhetorical, because the slave narratives were not addressed to the government or to the church or to the former masters, people, they are talking about material things that are owed to them. And I think that we should be looking at that dimension. I'm not saying that the symbolic dimension is not important. I think that there are some of us who are doing that. I plan to continue doing that work either. But I think that we should continue digging more, because the point that Robert made here, I think that is important. The fact that many people think that reparations is an invention of the 1990s, that some crazy activists decided to bring that to the table, and it's not the case. Then, as a historian, this is inaccurate, and I think that we should retrace as far back as we can, and I am sure that other people will be doing research even in other archives that we are not able to touch because of language barriers or so on, and that you are going to find there more evidence of this claim. Thank you.
Professor Araujo.